The Honorable, the Judges of the United States Court of Appeals for the Fourth Circuit. Oyez, 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 all persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Please be seated. All right, we'll begin with Overby versus Anheuser-Busch. Mr. Teich.
Good morning. May it please the court. The district court misapplied the Rule 23 and FLSA standards when it certified a class of hourly employees pursuing off-the-clock wage claims, despite overwhelming evidence of variability in what those employees, who had dozens of different job titles across 5 different departments, actually did before and after their shifts. The controlling...
I'm going to ask you to speak up and put that microphone close to you.
Of course, Your Honor.
Thank you.
The controlling Rule 23B standard, is that better? From Bojangles, which the district court did not cite, is that a highly generalized policy to violate the law, founded on a laundry list of factually diverse claims, cannot support certification. As in Bojangles, plaintiffs here failed to meet their burden of showing that common issues would predominate over individualized ones when proving whether each employee performed work and for how long, whether Anheuser-Busch knew or should have known about it, and their damages. The assortment of tasks employees testified...
Let me ask you about Bojangles here.
Sure.
In Bojangles, we had something like 311 or several hundred different little restaurants or outlets. And here we have a single facility outside of Colonial Williamsburg. Isn't commonality and predominance, are they not more likely when you're dealing with a single facility here than when we're dealing with 311 different facilities under different immediate management?
That might often be the case, Your Honor, but not necessarily, and I'd like to explain why. In Bojangles, there was only one job role. It was shift managers or assistant shift managers. Here, there are literally dozens of different job roles in this single facility. So it is yet only one facility, but there were 5 different departments, and the types of jobs varied greatly. Just reading through the joint appendix, you can see all the different job titles that are at issue: a brewer,
When
a
you
can
say 5 different departments, do we know that the PPE and the COVID task and dining and doffing were different among the departments, or were they same under sort of a common structure? That's one thing I haven't been able to figure out from the record, is how much variation there was from department to department.
Yes, Your Honor, there was a great variability among the different departments and among even job roles within each department.
Is that apparent from the record?
It is apparent from the record, and it was cited before the district court. The district court did not get into any of the evidence, but I'm happy to point to some of it right
Give
now.
us like some examples, like taking PPE as an example, whether you're doing it by job type or department. Is there any reason to think that there's variability there? I'm sort of with Judge Wilkinson. I've sort of tried to look through, but had a little difficulty piecing that together.
Right. Let's start with PPE, because I think that is one of the central supposed off-the-clock jobs that the plaintiffs point to. So for PPE, donning and doffing, okay, they say that everyone is subject to the same requirement to don and doff.
I'm looking at JA 848, which is a notice that appears to have been posted. It says in bold, all caps, surrounded by black, expectations mandatory for all, and then it has the PPE policy in it, and it says right at the top, mandatory for all in bold.
Right. So it's mandatory. PPE is mandatory for everyone, but let's break that down. So first of all, many employees testified that they put on their PPE during their shift, so they were paid for it. That's, for example, at JA 725 and 726, employee called Zubenko testified that when he put on his PPE, it was during the shift. Some put on PPE, but did so at home. So the PPE that was required was steel-toed boots, ear protection, eye protection, and something called a bump cap, which is a
But they
piece
were
of...
required under the policy to sanitize their boot bottoms, to sanitize their workstation, to wash their hands. I mean, it's a long list, and every one of these seems to be things that you need to do, or most of them at least, after arrival. And it's my understanding that there was a policy as well in place that all employees were required to be at their workstation throughout their shift, and that they were only paid for their shift, that there was a policy that they were paid exactly for their shift. And for this reason, they essentially had to arrive early to carry out all these tasks prior to beginning to sit at their workstation and do that work. I mean, they can't wash their hands and sanitize their boots at their workstation, right?
Well, some of them can, Your Honor, depends on where the sanitation is. But let me talk about this PPE because I think it's really important. I think the best place to look for the three of you is on pages 14 and 15 of our reply brief, where we walk through what a single employee does depending on her different positions. This is Abby Gearhart. She's one of the named plaintiffs, so we're not cherry picking. She says sometimes she has to retrieve or put on specialty PPE like Kevlar gloves for handling bottles or chemicals, sometimes impact gloves for grabbing pallets, sometimes wetsuits and boots for cleaning. Sometimes she has to put on sleeves and gloves. She testifies she does many of those things after her shift starts, so she's paid for those activities. Other times she alleges she had to do it beforehand. So I'm saying even for an individual employee, there's an incredible amount
Can
of
you go back
variation.
to Judge Berner's question again? So I understand there's like, everybody has to do PPE.
Correct.
But I guess I think this is what you're getting at. It sounds like you're saying for a given person on a given day, as well as for different job titles, what that PPE is varies.
That's exactly-
the point that you're
That's
making.
exactly what I'm saying.
So the reply brief talks about how it varies by person, so that particular person does different things, and so PPE looks different on different days for that person. Can you point me where I might look to see variability in the PPE across job types or departments?
Sure. Let me give you two concrete examples. Number one, a JA 784. This is an employee called Brinson. He's an opt-in plaintiff. He says, I'm a tech planner now, but when I was a maintenance tech, I had to do more preparation prior to my shift than I do now. Different preparation. Okay, we have an employee called Zubenko.
But
who-
do we know that that's what he's wearing versus prep? Well, how do we know what preparation means there?
Well, let me talk about I think he's referring to PPE there, but this is another example. This is, the employee's definitely talking about PPE. This is an employee called Zubenko. He says, oftentimes for his job, if he was a maintenance person, he would only have to wear the normal PPE, which was eye protection, ear protection, bump cap, which is a piece of plastic put into a baseball cap, and steel-toed boots, some of which he would put on after he arrived at the station. But for other jobs, such as when he was on the chip crew, which essentially required going into the tanks and cleaning it out, he had to put on a full-body wetsuit and rubber gloves and rubber boots, but he testified he did so after his shift started, so he was paid for that work. So the point is, for any individual employee...
Were there other employees who did the same task but were not paid for the work? I mean, as you're saying, the essential variability is that some employees perform the task, but they were on the clock and they were paid for the work, and that others perform the task, but they were not paid for the work. The question is whether the tasks were on the clock or off the clock, and that's the variability?
That's one piece of the variability, but also what they did. Again, if you look at page 14 and 15 for Gearhart, she said it varied day by day. It depended on what she was doing. If she was cleaning bottles, she had to put on one type of PPE. If she was cleaning tanks, she had to put on a different type of PPE. If she was doing maintenance, she didn't have to put on any specialized PPE, just the steel-toed boots and the ear protection and the eye protection.
Well, what about this? Just maybe this is hypothetical, maybe it's accepted as a hypothetical. Imagine that, as I think is the policy, is that there is a baseline PPE that everybody has to wear. You have to wear steel toe boots, eyes, ears, and the cap. And imagine that there was evidence that it took 5 minutes to do this, to put on, boots. I don't know whether they're put on at the facility or at home, but let's just say it takes 5 minutes to do that.
Right.
And everybody has to do that, and maybe some people do more than that, and some people, what they do varies, but that's just a baseline. Why wouldn't that be like a common question? And so maybe recovery for other stuff doesn't work, but that 5 minutes, and accept that they could show that it takes 5 minutes through some representative data.
Yeah.
Why wouldn't that, at least in theory, maybe that's not this class, but why wouldn't, in theory, could that class work?
In theory, Your Honor, yes, that's Tyson's
That's
food.
sort of Tyson food, right? That like,
Absolutely, but the point is we're miles away from that here. There's not a single task or activity. In fact, the district court didn't even restrict the universe of potential off-the-clock activity. She said things including PPE, including COVID. We don't even
and so,
know what and the plaintiffs
just to
haven't restricted
make
either.
sure I understand, your argument is effectively like a procedural objection. You're not saying that there is no class that could be possibly certified here. You're saying the class that was certified in the manner it was certified was improper.
Well, it's both a procedural and a substantive class. We think this case is very much like the Ferreris case, which was a 200-person class of all hourly employees at Newark
To follow
Airport.
up on Judge Richardson's point, if the variation is between those who perform the PPE post on the clock and those who performed it off the clock, whether they performed it before going to into their shift or afterwards, wouldn't that be amenable to what you're saying, that this definition at present is too broad, but it might be amenable to subclassing if this baseline requirement that Judge Richardson mentioned was performed by a significant number of people prior to the shift, and that they were not compensated for it.
Well, Your Honor,
I think one of the hard questions you have to ask yourself here is, maybe this definition as it's presently formulated is too broad, but aren't there a variety of potential subclasses here that would catch commonality for a significant number of people?
that's possible, Your Honor, but we think.
Well, if it's possible, why shouldn't the case be remanded for purposes of subclassing? Because it does seem to me that if there's a baseline requirement here, then there's a potential commonality and predominance both.
Well, we think the even PPE, even COVID and other things, there's too much variability even in those. I think at a bare minimum, this needs to be vacated for the same reasons that Bojangles had to be vacated. But we actually think this case is more like Ferreris, where it was just a straight reversal, because the court said there's just simply too much variability even among the.
What is that? How is?
You want the case not just remanded, but dismissed?
No, reversed and sent back to the district court for proceedings with the individual.
What exactly you want? You have no objection to having this sent back to the district court to see if there's subclasses that meet commonality and predominance?
Well, we do object to that because we do think that this was plaintiff's class. This was the class that they proposed.
You think
they didn't try to restrict
You think
it.
there's no possibility at all that a subclass can be formulated that meets commonality and predominance requirement? You say that's just impossible? There's no possible subclass?
I did say it was impossible, Your Honor. I said I think the appropriate response would be reversal, but if this court thinks that there's some, that the district court should have the opportunity.
Just help me understand, does it matter? Because, class certification can be reconsidered at any time is sort of the theory.
Right.
And so why does it even matter whether we reverse or vacate? Like the district court could reconsider class certification, when new information comes out, either way.
That's right, Your Honor. We think reversal is appropriate because the district court, this was the class the plaintiffs proposed. It's clearly not certifiable. It violates the Bojangles requirement of including even uninjured class members, everyone who worked at the facility. So at a bare minimum, we think it has to go back to the district court. Reversal or vacator at the end of the day, I don't think makes a huge difference. I just think the court should make clear that a class with this level of variability requires the district court to do more, to actually engage with the evidence. This is not a mere pleading standard at this stage. The district court is required to actually engage with the evidence and figure out, are there
But it's really hard for
certifiable
us
classes?
to evaluate. I mean, that, you're saying reverse and tell them to don't certify. It's really hard for us to evaluate whether there could be or could not be like appropriate subclasses or narrow definition. I mean, I don't even know how I would write an opinion that says, oh, like, let me dream up a subclass and tell you why it wouldn't work. That seems like an odd thing for us to do. Like, we are, as we repeat a lot, right, of course, a review.
May I answer his question briefly?
Sure.
I understand, Your Honor, and if vacator is the appropriate response, we accept that. I think part of the problem is the district court just didn't engage with the evidence, so it's hard for this panel to review. It just kind of assumed, based on allegations and plaintiff's assurances, that it could try this case. Thank you.
Mr. Tucci?
May it please the court, Robert Tucci on behalf of plaintiffs and the putative class. Just to address your question, Judge Wilkinson, regarding the PPE differences here, let's really analyze what happened in the brewery at the Williamsburg Brewery. So the workers, the hourly workers, at minimum, had to don and doff certain PPE.
But the question that he raises, that Mr. Tice raises, is when?
That's correct, Your Honor. And so,
And I mean, that would seem to me a pretty crucial thing as to whether they don and doff on the clock or off the clock, and whether that's compensable or whether it's not.
And
Isn't that a significant variation?
Your Honor, the benefit here is we have two policies by Anheuser-Busch that were required of every single hourly employee. The first was they had to be at their workstation, ready to work at the start of their shift. The second is they had to work to the whistle, meaning they had to work to the end of their shift and remain at their workstation until their shift ended. Necessarily, they had to don and doff their PPE either before their scheduled shift to don or after their scheduled shift to doff.
Take the boots as an example. So do you agree that the PPE that was required of everyone were boots, eyes, ears, and the bump cap?
That's correct, Your Honor.
Right. So is there any reason to think that, like, the employees changed shoes when they got there? I mean, this seems like an odd thing. I mean, I get you have to have steel-toe boots, but I didn't see anything that suggested that people were, like, donning and doffing their shoes.
Of course there were, Your Honor. Actually, there's a significant majority of the class members who don and doff their PPE at the brewery in their locker rooms.
And so where do we get that? The significant majority do that. Can you just point me to where that is? And then sort of the follow-up question to that is, okay, you got a majority that do it at the facility versus, a minority that does it at home. Why isn't that the sort of like an example of the variability that creates a problem, right? You might define a class that says, for those that put PPE on at the facility, right, they may fall within a subclass. But for those that, prepared them at home, maybe they look different under the law. I'm not trying to take a view on what the state law requires to be compensated. But you might imagine the law looks different if you're putting the boots on at the facility versus putting the boots on at home, because you got to put some shoes on. You see what I'm saying? Why is that variability not part of the problem here that the district court just didn't grapple with?
So with respect to your first question in the record site, I don't have a specific site in terms of the majority, but at JA 499, that's Tom Joker's deposition. He was a general manager for the Williamsburg Brewery. He testified in terms of the required PPE and generally how that process flows within the brewery, and as well as Kristen Kraft at JA 1637. That's her deposition transcript and testifying along the same lines there. Now, in
But
terms-
along the same line, saying that the majority of people put steel-toe boots on at the facility?
Not the majority, Your Honor. I don't have a record site at right now ready for you.
But you're
regarding that.
representing, this is not a gotcha game, but you're representing to me that there is a record site for that, you just don't have it.
That's correct, Your Honor, yeah. And then additionally, in terms of the variability, this case maps perfectly onto Tyson's Foods. In Tyson's Foods, there were variabilities. In fact, that was the entire purpose of the case. Dr. Kenneth Miracle, who was a plaintiff's expert in that case, performed a time study, and then there were two primary variabilities. One was with the cut and retrim department, where he estimated 18 minutes of work was performed for donning and doffing the PPE there.
Well, I
And then the
understand
kill
that, you
department.
know, the Tyson's Foods says you can have representative evidence and you can average it out and you don't, and even some variability with respect to damages and variability doesn't defeat class certification. But it surely complicates it to try to, that's a significant it complicates administration of the class when the commonality is not present on the surface, and when you have to determine, well, what the average worker did, or what might be the average damage suffer. So, yeah, I understand Tyson's Foods, but isn't there a limit to the degree of, to the extent to which we can say, oh, well, we'll get representative evidence, and we'll find out across a whole array of people what exactly they did and what exactly they didn't, and then we'll try to take some sort of common theme or common norm, and that because part of our inquiry has to be, is the class device a better way? It doesn't have to be the best, but is it a superior way of going about resolving this case? And if you have a Tyson's Food question, doesn't that complicate the administrability of the class mechanism when you have to go Tyson's Food and representative evidence, rather than just taking the commonality on its face, which is apparent in many cases?
Well, Your Honor, I think the time study and the Tyson's Foods inquiry really goes to manageability. Now, commonality predominance are certainly established by the common policies, the common requirements of the employees at the brewery. It's not a barrier to commonality or predominance to have certain variability among the workers. With Mount Clemens, for example, because Anheuser-Busch is claiming that its own time records are not accurate, plaintiffs can certainly come forward with their own estimate of the time periods at issue, and those time records should be established by a just and reasonable inference.
But you're saying to me, well, we're not seeking compensation for the time that someone spends at the gym.
That's correct, Your Honor.
And we're not seeking compensation for the time that someone spends with a cup of coffee. That we're only seeking compensation for the time that they are actually spending donning and doffing, the putting on equipment. But is that going to be that easy, really, in determining, as a general matter, what percentage of the time is spent by the average employee with coffee and at the gym, as opposed to donning and doffing the equipment? I mean, isn't that a complicating factor and a difficult inquiry to sort of break down what percentage of time is being spent on coffee and at the gym, and what percentage of the time is spent donning and doffing required equipment?
Your Honor, we wouldn't be looking at percentages in terms of what's used for personal time versus what's used for donning and doffing or other pre- and post-shift activities. What we would be doing is using our time study expert and our damages expert to approximate the time periods at issue. If Anheuser-Busch wants to claim that those time studies or those representative evidence
Can you,
is not...
can you describe to me how you would do this? I asked about the PPE. How would you do that with respect to the handoffs, which I think are somehow included in this class? I have a little hard time exactly understanding, because there doesn't seem to be any suggestion that they're uniform in any, like, meaningful sense across the various job titles that we have here. How in theory would we do that?
Well, Your Honor, it's for the handoff specifically. There's 2 points. The first point is, under the continuous workday doctrine, the compensable time starts with the first principal activity. That's under Alvarez Supreme Court case. So because the donning and doffing necessarily takes place before the handoff even occurs, and the COVID screenings as well, that analysis really wouldn't come into effect in terms of whether that's compensable or not, unless those activities are not compensable. Second point is...
I don't understand that. Say that again. That may just be that I don't, those words didn't make sense to me. Try it one more time.
No worries, Your Honor. So PPE must be donned before the workers can enter the production floor.
Totally fair. I get all that, right? But when even if your claim prevailed on PPE, you have this like inclusion of pre and post shift handoffs that seems to be neither here nor, like, it seems to be all over the place. The question is, like, how do we see some commonality or predominance with respect to that part of this? Because you're trying to include that as part of the policy, I think, at some level. I guess I'm just having a hard time understanding.
Right, and that's kind of where I was going with the continuous workday doctrine, because even if those activities were not integral and indispensable to the principal activities of the workers, it would still be compensable under the continuous workday.
I totally understand that, but what we have is, we have widely varying times, if any, for those handoffs. And so, it based on what I can see in the record. And so I understand your point. If we could figure out how much time was spent, and how much time was spent on handoffs was indeed uniform, right? That might be a useful piece of information. But what I don't see here is any indication that there's common predominance with respect to how much handoff was being done by different jobs at different times, and whether it was being done before or after the shift started.
It's simply an issue of estimation, Your Honor. There's 5 departments. And so if we look at...
And hundreds of job titles.
Well, for each department, there could be a time study performed just like in Tyson's Foods, right?
But before you can do a time study, you've got to have some commonality, right? You don't get just to say, like, we have these wide variations, but we could just do a time study, and we'll average, to use the example other on PPE, we'll just average the guy putting on the wetsuit with the guy that's putting on a pair of boots, and then we'll award that much money to all of them, right? The wetsuit guy is just different situation than the boot guy. It might take some people longer or shorter periods of time to put on boots and eyeglasses, but the person putting on the wetsuit seems to me to not be part of the same time study, that we just throw it all in and sort of average it out. That seems like the commonality problem.
I disagree, Your Honor. I don't think the record indicates that it's that variable. But even if it were...
What is that variable? That you think the record doesn't show that some people put on wetsuits as PPE?
No, I do. I think in terms of the handoffs, in terms of it being per position level of variability, I think certainly by department that's warranted. But in terms of addressing the variability...
Wait, by department? But the class doesn't treat them differently by department.
Well, Your Honor, that's more of a damages issue. It's not really... all of these workers were subject to some level of pre- or post-shift work.
Give me the cite for that. So if I wanted to write that sentence in an opinion that says the evidence below showed that every worker was subject to some pre-shift handoff that was before their shift started, what would I look at?
Not in terms of the handoff necessarily, in terms of pre-shift work and post-shift.
I know, but I'm asking about the handoff, right? I thought you just said everybody had pre or post-shift handoff.
No, my apologies. If I said
Okay.
that, that's not...
But we agree that not everybody had pre or post-shift handoff.
For certain days, maybe not. for individual workers. Now, whether.
But the class includes them whether they had it or didn't. So they're going to get compensated for it. This class would treat them as having had it.
Well, a good comparison to that, Your Honor, would be Bojangles. The pre-shift checklist only applied to 80% of the shift managers in that case. So that, the court found no problem with commonality or predominance for that claim. It would be no different here.
But do you think in Bojangles, the class could have included the 20% that didn't have the checklist?
Of course, yes. And then at the damages stage, the workers that did not perform the work would not be awarded the damages. Mount Clemens answers this problem. The Supreme Court addressed this over 80 years ago. It's a burden-shifting analysis. The plaintiffs come forward with their representative evidence or time studies to establish the amount and extent of work as a just and reasonable inference. The burden then shifts.
Let me ask you one question. I'm very uneasy with the way that the class has been formulated. And Judge Richardson does suggest a number of fault lines in the class where there are there's enough variability there to give us concern. One question I had with respect to variability was, are there workers here who are being in the class and dumped into the class who were only hired after the COVID threat had eased and the COVID protocols were taken off?
Oh, certainly, Your Honor. We haven't
But
seen the
that
class
isn't a-
list, but
isn't that a significant, if we're trying to throw into the class employees who were working during the protocols where the tasks assigned were greater, and those who were employed after the protocols had been lifted? I mean, and yet somehow they're all part of the class.
Your Honor, I think you're looking at the per task nature of the case rather than the actual underlying what's required of the merits. Simply the question is, was work performed that should have been compensated
No,
for,
the
but
question
wasn't?
is whether there's sufficient commonality to have a class. And one of the things that concerns me is that it seems to me that there could be dramatically different requirements depending on whether somebody worked while the COVID protocols were in place and somebody who worked after the protocols were lifted. Then those are different groups.
Well, the class certification is individuals who were employed at any time starting July 1st, 2020. At what point, I'm assuming that these COVID protocols were in place at the point that this class date begins?
That's correct, Your Honor. Then the COVID screenings went through January 2023. And Judge Wilkinson, in terms of your question, Anheuser-Busch agrees with us in terms of the overall scope of the merits. They, on their reply brief, they cite in their introduction 2 questions that are
I want to know
central.
whether they are members of the class or whether the definition now that is proposed for the class includes those who were employed after the protocols are listed.
My apologies, Your Honor, I missed your question.
What? I want to know whether the present class definition includes those employees who went to work and were employed only after the COVID protocols were lifted.
Your Honor, we have not seen the class list, so I can't represent to you whether that is
Well,
true
how
or
could
not.
I mean, there bound to have been some people who were employed after the protocols were lifted. You don't need to see a list.
Well, Anheuser-Busch has represented that, but I cannot represent that to you because I don't know.
Well, was there any practical reason? You said, did they somehow stop hiring people after the protocols were lifted?
No, Your Honor, I'm not saying that. I
No,
just
they
don't know for a
continued to
fact.
hire people, so there must be, in these kind of jobs, there must be a decent degree of turnover. And so the present class, the class as it's presently formulated, would include people who were never subject to the protocols at all.
I don't know where that's at in the record, Your Honor, but we certainly have not seen the class list. But I'm not disagreeing with you that new employees could have been employed. I just don't know that
Do you
for a
have
fact.
any objection to a subclass that takes into account that variable?
I would, Your Honor, because every single class member, as it's defined right now, performs some level of pre or post-shift
Well,
work.
what about the people who were employed after the Virginia statute was amended? You've got the VOA statute, and then there were employees subject to pre-amendment, and there were employees subject to post-amendment versions of the same statute.
That goes to damages, Your Honor. It's simply a matter of what part.
No, it doesn't just go to damages. The fact that you can't just completely separate the class definition from damages. Often the damages stem from, they're really sort of interrelated, because the variability in damages often is an outgrowth of the lack of commonality among the class. Those are not two, you can't, they're different, I get that, but they can't be cleanly bifurcated.
Well, sure they can, Your Honor. It's just a matter of what part of the pre and post-shift tests were compensable
No, but the
during.
fact that they are very different calculations of damages can trace back to the fact that there was a lack of commonality within the class.
Your Honor, we're not proposing a different method to calculate damages based off of a different law or so forth. We've proposed a time study expert, we've proposed a damages expert. Both will be able to easily and manageably address the issues in this case. For the VAWA pre-2022 amended version, it's just a matter of what part of it is compensable, what part of it can be paid to the class members. That's during that time period. We're not addressing the pre-2022 amended VAWA post-amendment.
Can I ask a maybe higher order question? So I understood Bojangles to suggest that one of the challenges is sort of the level of generality problem, and this is a problem obviously that pervades law as a general matter. But I take your class definition effectively to be like, this is work that was unpaid, right? Because it's before the time started, before your shift started, or maybe after sometimes too. I can't quite figure that part out, but and that's sort of how you're defining it. And I sort of understood Bojangles to say you have to actually do it by policy. And so that you would have to actually define this by like the PPE policy. And so that might be a group or a subclass of some sort. The COVID policy, like that's a different policy. The handoff might be yet a different policy. And that simply trying to aggregate those as saying uncompensated work is the wrong level of generality. Can you respond to that? And I'm sure Judge Wilkinson will give you a minute to do so.
And if I may have a moment to respond, Judge.
Yes.
Yeah, sure.
Thank you.
Yeah.
Your Honor, the difference between what Bojangles described as a general policy, so to speak, that's more going towards commonality and predominance. The class definition, if it's, in this case, Anheuser-Busch's objections to it are really form over substance. There's no class member that didn't perform pre- and post-shift tasks, ever.
At that level of generality, right? Like, fine, but the problem is you've just defined it up a level of generality, right? We know that there were class members, or at least accept my hypothetical, there were class members who did not go through COVID screening because they were hired after January of 23, right? So we don't know that with respect to all of them. If we look at the level of generality being each policy, you just want to take it up to a high enough level of generality, which is what Bojangles tried to do as well, and say, well, we'll take these different policies, and if we group them together in a way that suggests that it's like when the law was violated is our definition, well, then they look common because we've like aggregated disparate things up into a single high-level generality point.
Well, Your Honor, Bojangles, in terms of the generality, the district court there only cited this pre-shift checklist for a diverse range of claims for both pre- and post-shift work.
And I take Bojangles to say you need to look at the actual policies, right? You can't do this sort of aggregate thing. And what you seem to be doing here is an aggregate thing. We're taking multiple policies, right? The COVID policy is different than the PPE policy, is different than the handoff policy. And you're trying to create sort of a generalized policy of don't pay your workers what they're owed.
Your Honor, I think, just as our friends in the National Employment Lawyers Association and Metropolitan Washington Employment Lawyers Association in their amicus brief indicated, there is no written policy requirement under the FLSA or these wage laws. There just simply is not.
No, it doesn't have to be. And so the handoff policy might not be written. I don't care if it's written or not. Some of these are written, some of these aren't. But that doesn't make a difference, but they are distinct. But you just think we should, move them up a level of generality so that they can aggregate and create common questions.
There's no generality here, Your Honor. The policy is Anheuser-Busch compensated its hourly workers for their scheduled shifts. That's it. Unless an exception was made, which they have pointed to nothing in the record indicating an exception was made for PPE or COVID screening or so forth.
Judge Richardson makes a good point, I think, because what we tried to do in Bojangles is say, please do not send us something that is just as broad as all outdoors. Please do the defining and the specificity work that's necessary for commonality and predominance. Please do that at the district court level. And please do not send us up here something that is broad and has all kinds of disparate groups folded into it. It's not that that Bojangles was unreceptive to class certification. But as Judge Richardson says, it was skeptical of the level of generality that's being adopted in class definitions. Work that should be done at the district court, work that would give rise to a legitimate class that would easily satisfy Rule 23A and 23B, if only a little bit of the specificity work would be done initially. And that is the difficulty. I'm not unsympathetic to the idea of compensation for workers for donning and doffing and for certain tasks and everything. It's just the fact that when I look at the definition of the class here, immediately came to mind, well, there's this segment and that segment and this difference and that difference. I think Judge Richardson has pointed out a number of those differences. And I have some others that I'm concerned about. But it's not to say that you can't find a class action here. Do you know what I'm saying?
Judge Wilkinson, I think I do, and my response would be the class members, at minimum, are similarly situated. They don't have to be identically situated.
No, you're right. You're right about that. And I don't think that it's going to be impossible to have you can't have identicality with that many people involved.
And so at some level, every class member here performs some pre-shift, some post-shift tasks. Why would we need to separate the different tasks in the class definition? It's form over substance. We can address that at the damages stage. There's no need to do it in the class definition. Why would we send separate notices out to these class members for each task?
Do you agree that at the damages stage, that there are going to be different damages models for different job types?
There will be different estimates for different tasks performed for different jobs or different departments, certainly, Your Honor. And we would just ask that the court affirm the district court's decision in full certifying the class. Thank you.
Thank you, Mr. Tice.
Thank you very much. I'd like to make 3 points, if that's okay. I'll start off with the Bojangles point. My friend on the other side says, well, everyone performs some pre-shift, some post-shift tasks. Anheuser-Busch disagrees with that, but that is exactly what happened in Bojangles, where everyone alleged there were certain tasks before and after their scheduled shifts.
I'm not convinced. I think there may well be a class action here as long as it's properly defined. I don't want you to misconstrue my comment or what I think Bojangles was getting at. It's not to say that there can't be a class action, and there may well be a class action here, and these folks are not seeking compensation for going to the gym or having a cup of coffee. They're not asking for that.
Correct, Your Honor.
But the question is, again, you know, I just think that there are a number of ways in which this definition can be made more specific and in which subclasses can be made that, because those rules of, I mean, the Supreme Court's made it clear in innumerable cases, Anhelm and others, that these requirements of commonality and predominance have to be taken very seriously.
Correct. So, Your Honor, so I take that point very seriously, and you can imagine a class like in Tyson's Food where there's a single type of activity, donning and doffing, and if the plaintiffs want to propose that on remand and say, we'd like to propose a donning and doffing class, then we can have a fight in front of the district court about whether the tasks are sufficiently common among all the different departments. On that point, I would urge the court to read JA 1199 for about 5 more pages through 1206. That's a discussion of all the different tasks a single employee did pre-shift in terms of donning and doffing. She said it depended on the job. Sometimes she didn't do it at all. Sometimes she had to put on a lot. Sometimes she did it during her shift. I think that gives you a good flavor of the kind of variability we're talking about here. But, Your Honor, I take your point that there might be some hypothetical class. It's just the district court didn't find it.
They haven't, I mean, unfortunately, the class definition has all sorts of problems, but there is a core justice to what the plaintiffs are contending here, and what they're saying is, we're doing work that's required by the company, and we're not getting paid for it. And I don't believe it's not the kind of thing that can be written off with a de minimis exception. I don't go along with that.
Right.
The whole question is, we have to take those textual requirements in Rule 23 seriously, but there may well be a class action or several class actions here that will give these folks the payments that they're due.
Right. Well, that is their allegation, to be clear. We haven't had a summary judgment briefing yet. We don't actually know if there's a question of material fact along those lines, Your Honor. But I take your point that, yes, at this stage, the question is, do individual differences, do common issues predominate over individualized ones? And I think at least...
You said you had 3 points. You've hit one, it sounds like. Can you just quickly give us the other two?
Oh, sure.
Because I got one other question, but I want you to get your 3 points out.
Sure. Well, I've covered some of it in my responses
Okay.
to Judge Wilkinson, but I guess I would just say there's dozens of different job titles in this record: forklift operator, palletizer, QA analyst, ingredient analyzer, calibrator, et cetera. Each of those would require a different analysis to determine what they were doing beforehand. And I think it's crucial to know that this is, again, not a PPE class. It's not a donning and doffing class. It's not a COVID class.
Can I
it's
ask-
an open-ended class.
Yeah.
of
Can I ask the
off-the-clock work in
question
general.
that I asked your colleague?
Yes.
So if I read Bojangles in part to be about the level of generality problem, that sort of says you can't just abstract up to put different forms of off-the-clock work together. Can you tell me why you think your colleague's position doesn't work? Because he says, no, we have an actual policy here, and I take him to be that it sort of has 2 parts that work together. One is we pay shift time only, and 2, you must be at your station at the start of the shift. And if that's the policy, I take his argument to be, at that level of generality, we know that there's some work that is done before that. And what exactly that is, we'll figure out as discovery goes on. But that's the right level of generality for the Bojangles problem. Can you tell me whether you think that's the right level of generality? And if not, why not?
Well, I think a couple of things, Your Honor. I think do you mind if I answer?
No, please.
Thank you. A couple of things. Number one, it's the same generalized policy of being worked off the clock. That is what Bojangles said. If you look at the Bojangles allegations, they were very similar in terms of requiring various tasks before shift, requiring various tasks after shift. I think that's the level of generality. What they point to are allegations of a couple of policies that they allege Anheuser-Busch are in violation of the law, but there's actually nothing illegal about paying people for shifts or for requiring them to be at their stations ahead of time, unless they're requiring uncompensated work beforehand. And the main point I'm trying to get at is there's so much variability in this record by department, by individual, by shift, even by day. There were several employees, JA 1327, to do your pre-shift tasks very day to day. Yes, they do. Overby, named plaintiff. It wouldn't be fair of me to comment on what each individual employee did because everybody's different. If you look through the record, I think a fair reading, it's just at least this class that these plaintiffs proposed, they could have tried to narrow the class in line with Bojangles or other case law, but instead they tried this omnibus class that included everything, including changes in law mid-shift, including COVID testing that did or did not happen. I just think that for certain people, they admit on ECF number 107, note 18, that some class members did not go through COVID testing at all. Even COVID testing there were 4 different stages of COVID testing that ranged from, car checks to foot baths and temperature scanners on the way in, that ranged throughout the class. Some people were never exposed to it. Some people were actually paid. JA 1647, there's some instances where individuals were paid even for that COVID testing. So I just think at least on this record, on this class definition, it runs smack dab into what the court said in Bojangles, which is you've defined the class as everybody who worked there, even those people who did not actually perform any uncompensated work. It would require an individualized trial on a person-by-person, shift-by-shift, day-by-day basis to figure out exactly what everyone was doing. If they want to try on remand for a much narrower class, they're free to try to make that burden.
Thank you, Mr. Tice. Judge, do you have any further questions?
Thank you for indulging me.
We thank you both. We'll come down and greet counsel and move into our next case. Mr. Eisenstein, we'd be pleased to hear from you.
Thank you, Your Honor. May it please the court, Mr. Eisenstein and I represent a number of private landowners that are in the path of a proposed power line which has not yet been approved by the Maryland Public Service Commission. The district court erred in issuing a preliminary injunction because PSEG did not satisfy any of the elements or the 4 factors under Winter versus Natural Resources. I'm going to be addressing only the first factor, success on the merits, and my colleague, Mr. Eisenstein, will address the other factors. PSEG cannot succeed on the merits because PSEG, as a matter of law, cannot invoke access provisions under Maryland Real Property Article 12-111. The language of the statute is clear. It applies only to entities, quote, having the power of eminent domain. There is no statute anywhere in the Maryland Code containing a delegation of eminent domain authority to a transmission line developer that does not have a certificate of public convenience and necessity, or I'm going to call it a CPCN for short.
Do you agree that once an entity got a certificate that they have, quote, have the power of eminent domain at that point?
Yes, they do.
And at that point, in order to actually condemn land, do they still have to go through the Title 12 process?
Yes, they do. They would have to go through the Title 12 process. That's not under 12-111.
Yeah, no,
That's
no.
the pre-access, but yes.
Right, and
After
so-
that, they would have to continue on to condemn the property.
But you agree, once they get the certificate, they have, in the statutory language, at that point, they have the power to exercise eminent domain,
That is correct, Your Honor.
even though that power is conditioned on compliance with Title 12.
Correct.
Right. So why does it matter if their power is conditioned on two things rather than one? So you agree that they don't have to have like the literal power to execute, right? Because they've got to go through Title 12. So why is Title 12 different than 12-111? It's just an additional condition on the class of entities that can exercise the power?
Yeah, 12-111 specifically requires that you have to have the power at that time in order to proceed with 12-111. And so that's why
But the
it's different.
certificate, to get the certificate, they're part of the class of entities that can seek a certificate, right?
That can seek a certificate.
Right?
yes.
And so the question I'm just trying to figure out is, once we agree that having the power doesn't mean the power to execute, because everybody has to use Title 12 in order to execute, why does the additional hurdle of getting a certificate take the power away?
Because having the power of eminent domain means that you have received that power by delegation from the state of Maryland. That's what we're talking about. Nobody else has the ability to give this power to PSEG. It has to be delegated by the legislature.
By the legislature, though. It can't be
Right.
delegated by the executive, right?
That's correct. It has to be
Right, and-
delegated by the legislature, and the legislature here delegated it in a very specific way with specific requirements. And what it says is that it's delegated on issuance of a CPCN.
But I thought you just agreed that you can't have delegation by the executive, right? So the Public Service Commission can't be the one that delegates the power. It has to be the legislature.
Right, but the legislature.
So that means that the legislature delegated the power ex ante, but then gave the Public Service Commission sort of a condition on the actual exercise of that power.
I don't.
Right? We
think
have to
that's-
look to the statute.
Right,
And so if you agree they had the power after the certificate,
right.
and we agree that only the legislature can delegate the power, well, then the Public Service Commission could not have been the one that delegated the power. It had to come from the statutory scheme.
Right, but it's not the Public Service Commission that's delegating the power. It is the legislature setting up the delegation and indicating in the statute when that delegation occurs. It doesn't occur before the issuance, it only occurs on issuance. So that you have to have a delegation in order to have the power of eminent domain. And what we are arguing is that under the public.
All of the different provisions of Maryland law seem to operate, whether it's a grant or whether it's an exercise of a power of eminent domain, there seems to be a single underlying assumption to all of these different provisions of Maryland law, and the assumption is that of a power that already exists. And the power that already exists is the power of eminent domain. And all of those statutory provisions are traced to that underlying presumption.
The underlying presumption that you're referring to, Your Honor, is that the state has the power of eminent domain. The legislature has the ability to delegate the power of eminent domain, but that does not mean that the entity who receives that delegation has that delegation before the legislature delegates it. And what we're saying here is the legislature made a delegation, but they specified who they were delegating it to. They did not say they're delegating it to an entity who just happens to be an applicant for a CPCN. They said they're delegating it to an entity who has been issued a CPCN. So it's not a pre-existing power of eminent domain that this private company who has no prior approvals from the state of Maryland whatsoever has. They only have it once the Public Service Commission has issued a certificate. That's when they get it, according to the plain language of the statute, which says on issuance. And other statutes don't require that, but this one does. They are specifying who gets it. And it's reasonable for the legislature to say, we're not going to give it to an entity that has no approvals whatsoever from the state of Maryland other than this. So my time is up, Your Honor.
Thank you.
Can I just ask one quick question? Of
course.
You're asking us to construe Maryland law, and I'm wondering whether you would have an objection to us certifying this question to Maryland's highest court.
I certainly would not. Thank you.
Thank you.
Your Honors, Harris Eisenstein. As Mr. Wyand presented, I'll be addressing the remaining three arguments for injunctive relief. As this court knows, it is a very high burden to get a preliminary injunction. PSEG cannot satisfy the first element, nor can it satisfy the remaining three. I'd like to touch on irreparable harm first. The district court found that PSEG's unapproved transmission line, quote, could be substantially delayed in the absence of a preliminary injunction, and that PSEG's prospective financial losses resulting from that delay constitute irreparable harm. First, economic losses generally do not constitute irreparable harm. But in any event, PSEG presented no evidence, zero evidence of prospective financial losses. All they presented to the district court was the total amount previously spent on consultants and attorneys. And the record establishes that PSEG can recover 100% of those costs. The district court's conclusion on irreparable harm was built on compounding assumptions. The first assumption was that with a preliminary injunction to
Who do they recover the cost from?
they recovered through the FERC order, Your Honor. Prudently incurred costs are recoverable 100%, and it's a presumption.
But if built, right?
If abandoned, Your Honor, actually, if abandoned. That's how they recovered. It's an abandoned plant incentive in the FERC order, which is found at JA 2251 through 2255. So these compounding assumptions, first, that with immediate access, the PSEG will secure a CPCN. Second, they will then build a 67-mile transmission line above ground through greenfields across 3 Maryland counties. This is the most ambitious transmission line that Maryland has ever seen. And the third assumption is that PSEG will
What makes it ambitious, just out of curiosity?
It's just the largest project that Maryland has ever seen above ground
What does
transmission
that
line.
have to do with the preliminary injunction? It may be that the needs are significant. When you, one of the things that concerns me here is that I know that the likelihood of success on the merits is a critical winter factor, but there are also other critical factors. One of those is the question of the public interest. And here you have a situation where if the access is denied, or if it's significantly delayed, that the entire project falls apart. It's the kind of project where the final result is connected to each step in the chain. And I realize that the power of eminent domain is among the most disagreeable powers at the hands of government. And I understand the significant frustration that landowners feel when people are asking for access to their property and where the prospect of a transmission line lies in the balance. I understand that, but, sometimes the eminent domain, as distasteful as it is necessary. And part of what seems to me to figure into the public interest is if this project does not go through, there's likely to be a danger of significant blackouts for Maryland residents in the future. And Maryland may go the way of California in light of energy blackouts. And so I wonder if that shouldn't be part of our calculus. The other thing is that this is not just my assertion about where the public interest lies. You have a situation where the federal authorities have deemed this to be completely necessary. And you have not only FERC in dealing it, but FERC's regional authority thinking that this is a critical need for Marylanders in the future. And as we review the preliminary injunction, I agree that likelihood of success on the merits is crucial, but I also think that this is one of those cases in which all of the winner factors should not be overlooked. And given the fact that FERC has weighed in so substantially in saying this is needed, and FERC's regional branch has said this is needed, if we deny even access, isn't that going to cause the project to fall apart? And because in these kinds of cases, delay is often detrimental, is often every bit as detrimental to cancellation. That's just the way investments work and businesses work.
Sure, I totally understand, Your Honor. And if,
And so I'm concerned practically about if this thing falls apart due to the delays, whether we are not lending our hand to eventual blackouts in Maryland, so making it a situation where it resembles another California.
so, Your Honor, 2 points. It is true that PSEG presents this very dire situation absent their proposed power line, but it's also true that this proposed line is part of a much broader package of transmission solutions that FERC says is necessary. It's also true that though FERC and PJM have said we need more transmission in and around Maryland and PJM's region, which is 13 states basically east of Chicago, all of those local transmission projects have to be approved by the local bodies, here the Maryland Public Service Commission. And your point, Your Honor, with respect to the importance of all 4 elements, that's what I was getting at on
Are
irreparable
you
harm.
going to have another crack at this before the Public Service Commission actually finally rules on the certificate of convenience and necessity?
The Public Service Commission isn't set to receive final briefing until February of 2027, but the bigger.
Okay, but you're going to have another shot at it. You're going to weigh in on that at that level, aren't you? At that stage?
Me personally?
No, I don't mean you personally. I'm talking about your client.
All of the folks who are along the proposed route, many of them have.
The landowners are going to be heard at that point, before the Public Service Commission finally makes a decision on the certificate.
But it's a much different inquiry, Your Honor. It's on whether they can actually build the project and the actual location of the route, and if they're able to do both, then they can condemn. Remember, this is.
You're not answering my question. I'm saying this isn't the end of it, because what they're seeking here is, all they're seeking here is whether they can conduct studies and have an access and nothing more. And all I'm asking is, this is a very preliminary stage, is it not, in getting a certificate from the Public Service Commission. Nobody's digging in the ground here. We're talking purely about access to assess environmental harms.
It is true that nobody is building this line yet, and it cannot be built unless the Public Service Commission approves it. Thank you, Your Honor.
Mr. Fisher.
May it please the court. The threshold question in this appeal is whether under Maryland Code 12-111A, 111A, PSEG is a body corporate having the power of eminent domain so that it is entitled to take surveys. The surveys are necessary for a federally planned project in which FERC and PJM to have determined a need for a transmission line in order to forestall system failures and potential
You
blackouts.
agree with me that eminent domain is a thoroughly disagreeable step when the, when the state takes it. I
I
mean,
think
these are landowners and they care about their property, and many of them have spent their life savings developing their property. And it's, your view is that, yes, it is intensely disagreeable, but unfortunately, sometimes these things are necessary, which is why you have a power of domain up in the Maryland property law to begin with, and that without this transmission line, which a lot of folks more knowledgeable and well-versed than I am think this is important, if Maryland's energy needs are going to be met in the future, there could be some real problems if this thing collapses.
Well, I agree, Your Honor. I agree with the proposition that eminent domain really, as a practical matter, should be a last resort, that it's an extraordinary power that allows the government to take property by force.
So how does your client have the power of eminent domain under the statutory section that you just cited?
Certainly, Your Honor. The source of law that grants Transource the power of eminent domain is Section 7-207B3 of the Public Utilities Article. And for reasons I will explain in detail, Your Honor, Section 7-207B3 states two propositions that are clear and really indisputable. The first is that Section 7-207B3 identifies a federally regulated public utility. It's either a currently federally regulated public utility or a public utility that will be regulated when the line is in operation. It identifies them as having the power and authority in Maryland to construct a high-voltage transmission line and to exercise eminent domain in connection with construction. Now, what constitutes a federally regulated public utility is covered by federal statute and regulations, and both PJM and FERC have determined that PSEG, for purposes of this project, is qualified as a federally regulated public utility for this project, which is called the MPRP transmission line, Your Honor. Now, the second part of Section 7-207B, that's, I think, equally clear and undisputable, is that the exercise of the power of eminent domain is preconditioned on the public utility obtaining a CPCN from the Maryland Public Service Commission, or PSC, establishing the alignment of the transmission line, because the siting and the alignment is a state responsibility, and the need for the line is a federal responsibility. So the pivotal question really boils down to whether a federally regulated public utility such as PSEG must satisfy the preconditions to the exercise of eminent domain before it can constitute a body corporate having the power of eminent domain that is entitled to take surveys under Section 12-111A. The appellants contend that a federally regulated public utility, and then they don't contest that PSEG is will be a federally regulated public utility. They argued that that utility is entitled to take surveys under Section 12-11A only if it has satisfied the preconditions to the exercise of eminent domain, most particularly the precondition that a CPCN for the alignment, establishing the alignment, is first granted. So the surveys can only go forward under Section 12-11A, according to the property owners, if the CPCN has been awarded. That interpretation of Section 12-11A is wrong because it's inconsistent with the language of Section 12-11A. It's inconsistent with the legislative purpose, as explained by the Maryland Appellate Court of the statute 12-11A, and it's also, their interpretation would effectively it would render the CPCN process for the approval of high-voltage transmission line corridors, it would render them completely unworkable. And let me,
I don't disagree with you that it would render them unworkable. I guess I'm looking at the language of the statute, and it seems to me that it's not as clear as you suggest. And in particular, looking at the code 7-207 doesn't actually speak of the power of eminent domain. It speaks of the exercise of the right of condemnation, and I believe it extends that right on issuance of the certificate of public convenience and necessity, which it hasn't happened here yet.
Your Honor, the power is, may be exercised. I think under the proper interpretation of 12-11A, what the statute 7-207B3 provides is that the power of eminent domain may be exercised once the CPCN is granted. But in terms of what entities have been delegated.
Wait, I don't think you actually believe that either, though, right? Like, because it can't actually be exercised until you also comply with a second precondition, right, which is Title 12.
Well, that's correct, Your Honor. I mean,
Right?
that's correct, but in this case,
But it's different than saying it can be exercised, right? Because there are two preconditions here to the actual exercise by your client. I don't know why they're different, but one is PSC, and that's really energy focused, right? This is the sort of like alignment and need piece, right? And then Title 12, which is really like property focused. But those are just two separate preconditions on the power before it can be exercised.
That's correct. I believe Your Honor is correct that Title 12 contains certain procedural requirements that are also preconditions to the exercise of eminent domain. Because of the
But
language.
what that means, why that matters, I guess, and I just want to make sure I'm following. Why that matters is that you can't read the statute as suggesting that you have the power after the certificate, but before the Title 12. Either you can say they never have it until it's exercised after the Title 12 process, or you can say they have the power right now because they have the power to apply for the certificate and for the Title 12 procedures.
Well,
But what you can't do is put it in the middle of those two, right? They're just two preconditions on the exercise of a power.
I think that's correct, Your Honor, and I think that is the only logical way to interpret Section 12-11A to give effect to the language of Section 12-1A, which deals with future public uses. And it's the only way to reconcile it with the purpose of the statute as identified by the Maryland Appellate Court, which has said that 12-1A, its purpose is to investigate whether the acquisition of properties is appropriate for under 12-1A by taking surveys. And so if the interpretation that the property owners are giving were correct, if that interpretation were correct, then you're required to take the surveys in order to obtain a CPCN.
Can I ask a like first order question of like what our standard of review is here? It's a little odd because we review a preliminary injunction for an abuse of discretion. But here what we have is a very able district court judge who is making a prediction about the likelihood of success that is itself a prediction about what Maryland would do. So it's like nested predictions, right? The winter step one is a forecast or prediction of likelihood of success. And in this case, because we've got an eerie guess, it's a prediction about an eerie guess. Does that matter for our review? I mean, do we review those predictions or nested predictions deferentially at all? Or do you think because, the meaning of 207 is a legal question that Judge Abelson's prediction of a prediction just gets de novo review?
Well, I think that it is a question of law, and this court would have authority to review it de novo. I think the
Well,
interpretation
the question of law,
1211A
what the meaning of 207 is a question of law.
Yes.
But is a prediction about that a question of law?
I think in the past, on certain occasions, this court has deferred to a district court judge's sitting in the state and having an acquaintance with the law, and has looked at that, not with complete deference, because I think I could identify some circumstances where this court hasn't deferred to a district court.
We never
judge's-
have complete deference on
Right, so,
anything.
but I would have to, I'd have to agree that it's a question of law, but on the other hand, I think that there is a fair amount of fair deference that should be awarded to a district court judge that's interpreting
Let me
Maryland
ask
law.
with regard to that, if there is a fair amount of deference, as you've just said, isn't this one of those cases where, there are actually 4 factors in the winter calculus, and one of them, and a very important one, and in many cases, it's the most important one. But is this not also a situation where in reviewing the district court and according the district court with a certain deference, doesn't practicality enter into this case in several ways? First of all that's being asked is a preliminary step, and that is whether they can conduct studies. They're not asking at this point for anything more. And the other practicality is that there seems to be a considerable consensus that delay can defeat these projects as much as anything else, because that's just the nature of investment and of business activities. And you've got an awful lot of people at the federal level, both at FERC, and you've got people with a lot more expertise and experience than I have in this field. And there are times when, I pay attention to their expertise. And what they're saying is several-fold, and that is that if this project collapses or is significantly stalled at one stage, that the whole thing is in danger of collapsing. And if this collapses, that we are taking a significant chance with the provision of necessary energies for Marylanders in the future. That the practical consequences for the state of Maryland can be very, very serious. And we have experience and we have illustrations before us. We don't need to just sort of hypothesize completely, because we have experience with periodic blackouts and what that means to people's livelihoods down the line. And that's what you're likely looking at here. And the question is it impermissible to let that figure in the calculus? Are these practical considerations? Are they just beyond our ability to consider? And I can't imagine why that would be, despite my personal distaste for eminent domain. Sometimes it has to be exercised, and that's why the power exists in the first place. But talk to me about the practicalities and whether it's permissible to think about them.
Well, Your Honor, I think that the test is a 4-part test, as Your Honor articulated. I think all factors are relevant and important. I think that in this case, what's interesting, as Your Honor Your Honor articulated exactly what PJM said. It isn't PSEG that said this in in contradiction to my friend and colleague, it was PJM, the federal agency responsible for planning the grid, that said
Yeah,
that
the-
system.
That's right, the developer here is not, we're not taking the developer's word for it. We're not just saying, oh, well, the developer feels this is necessary, because that wouldn't be all that persuasive. You'd have to look into what they plan to earn. But here, you've got expert opinions, a process authorized by Congress, and you've got people quite outside the developer's orbit who are saying, this is important, this is necessary.
Well, they've made a finding, not only that it's necessary, but they've concluded that there's a substantial risk of system failure and blackouts if the line is not in operation by June 1st, 2027. That date will not be reached, and PJM has responded to that by saying, we can only mitigate at this point. If we're not going to have this line in operation by June 1st, 2027, we can only mitigate, but the substantial risk of system failure and blackouts exists in the absence of this transmission line.
Can you address, Judge Berner asked the question of your good colleague, and I want to give you the opportunity to respond to it too, about certifying this question to the Maryland courts, right? Obviously, there's an Erie guest at the core of this. It's sort of like a central state issue. I'm not aware of our court ever certifying a question in a preliminary injunction posture, but do you have any objection to that? I mean, you've got a preliminary injunction, so I guess you probably don't really care about delay. I mean, normally we would think certifying's a little bit concerning in a preliminary injunction context. It's an interlocutory appeal. We're trying to do things quicker. But your colleague said they had no objection. You currently have access, so maybe you don't have an objection either. You probably are fine just drawing it out. But
That's
just,
correct.
can you comment on that?
Well, I think that that as long as the preliminary injunction remained in place and we could continue performing the surveys, I can't say that I'm afraid of what the Maryland Supreme Court might do, so I don't want to say I would object to it. I think we are absolutely correct that under Section 12-111, that satisfying the preconditions to the exercise of eminent domain is not necessary in order to take surveys. That if you're identified and qualify as a entity having the power of eminent domain, and we've been identified and qualified by FERC and PJM as a federal public utility, that we have the power of eminent domain, and we just can't exercise it until we obtain a CPCN. And we can't exercise it until we satisfy the detailed procedural requirements in Title 12, as Your Honor pointed out. But we are a body corporate with the power of eminent domain. And to get to one final point, in terms of
But
the...
we have jurisdiction here, and there's been a preliminary injunction here, and it is, I do think would be unusual in a situation to certify something at the preliminary injunction stage, but also because there is a significant federal component to it. It's not, it isn't just ultimately a matter of state law, it is a matter of state and federal law and the collaborative relationship that they have designed, and there is a huge, significant federal component in this.
Well, absolutely, Your Honor. I mean, the fact, Maryland law identifies a federal public utility as an entity that can construct the lines and construct the lines and exercise eminent domain. But Maryland law therefore incorporates the federal law that we went through and regulations that we went through in detail in our brief, under which PSEG has qualified as a federal public utility. And and Your Honor's point is on the mark in my mind, because PJM and FERC have qualified PSEG as a federal public utility in the context of a PJM determination as to the need for the line, which is a federal, not a state responsibility. So I think federal law and federal policy is permeates throughout this dispute. There's just no question. There is, and I think as the Third Circuit recently pointed out in the TransSource case, there is sometimes a conflict between the interests of the state and the interests of the federal government that and PJM and FERC that have a responsibility for the provision of electricity on a regional basis. So I think
Well,
that
the
federal.
state's not being cut out of this because the Public Service Commission still has to issue the certificate.
That's
So
correct.
you're not cutting the state out in any way, shape, or form. The state remains part of the process. The Public Service Commission, its power to issue or not to issue the certificate of convenience and necessity is intact. It's not being disturbed.
I'm sorry, my time has expired. May I answer your question?
Yeah.
The role between the Public Service Commission in issuing a CPCN and the federal government in establishing the need for the line is well defined, especially after that TransSource opinion, which gave such a detailed historical analysis of this. The role of the Public Service Commission is citing, construction, and permitting of the line. So the Public Service Commission establishes the alignment, where the line will go, what properties will be affected, and will govern how the line, the transmission line will be constructed. But the federal government, through PJM and FERC, is responsible on a regional 13-state basis for determining the need for transmission facilities, the need for generating facilities, and to prevent congestion and prevent states from accumulating and benefiting from power and not benefiting their sister states, and allowing transmission so that electricity is stable and available on a regional basis. Thank you, Your Honor. Thank you. Appreciate the request that you affirm the district court. Thank you, Your Honor.
Did you have any questions? Okay. Mr. Eisenstein, you've got some time for rebuttal.
Mr. Wyan, thank you, Your Honor. I wanted to hit on the federal versus state issue here. The Federal Power Act has no power of eminent domain, so that's why we're here talking about the Maryland power of eminent domain. In fact, the Federal Power Act has a power of eminent domain, but it's only limited to certain very important, what they call national interest electric transmission corridors. And it's interesting, in the Federal Power Act, they use language very similar to what the Maryland General Assembly did here, where they say that the permit holder may acquire the right-of-way by the exercise of the right of eminent domain, which is very similar language to what we have in the Maryland statute.
Why
So,
wasn't the district court correct in relying on this TransSource case from Maryland Intermediate Court? It seems to be exactly on point.
no, Your Honor, and he was not correct because the TransSource case was wrongly decided. It was a trial court decision.
Decided by Judge Eves, who's
Yes.
now sitting on the Maryland Supreme Court.
That everybody can err. I believe that even I can err. And what I would point you to in that case is if you look at page 7 of the opinion, she says that it's a two-part analysis. And in the first part of her analysis, she starts with an assumption that TransSource was a public utility, and she says it was because the TransSource was an electric company. If you run down the statutes that she cites, you will see that TransSource is not an electric company. Electric company under Maryland law has to serve citizens within the state of Maryland directly, and TransSource did not meet that definition. PSEG does not meet that definition. So we are talking about out-of-state utilities, not what Judge Eves was talking about in that opinion. Now, I actually don't know the status of TransSource. Maybe Judge Eves was right about that assumption, but it certainly is not an appropriate assumption here. And for that reason, TransSource should not be controlling. I want to address one final thing, which is that having a CPCN is not just a precondition to exercise the power of eminent domain. It's a requirement to have the power in the first place. That's why
Why is it any, I guess I don't understand that argument, if I'm totally fair about it. Like, It's a procedural requirement, just like Title 12 is a procedural requirement. They're both preconditions on the ultimate exercise of eminent domain, right? They both have to happen before the ultimate exercise of eminent domain, right?
Yes, they do, but the question
So
is.
tell me why they're different. They're both just procedural preconditions on, the group that files under subsection 3 III, right? That's an electric company or, right, this sort of what I'll call the regulated entity, right? Which is subparagraph 2,
Right.
right? And so those two folks have to jump, both the electric company and the regulated public utility have to jump through 2 hoops, right? They got to get a certificate, they got to jump through the Title 12 hoops. Why do we think the certificate is somehow different than the Title 12 hoops?
May I answer, Your Honor?
Sure.
Because having the certificate is the grant. It says right in the statute, on issuance of the certificate.
No,
The
what it
grant-
says, it says on issuance of the certificate, they may acquire it, right? Right, means that this is about the execution, right? They may
Yeah.
execute subject to the next precondition, Title 12.
I disagree, Your Honor, and I would refer you to the other statutes whenever the
But it doesn't
Maryland-
say grant, right? It doesn't say we are granting you the power, right? What we're saying is you may acquire, right? May, right, doesn't suggest a grant of power. It's like an authorization to use a power, right? That's what may means. You may do this, right? It's something that you could otherwise do that I'm granting you permission to go forward with. Why don't I read the word may, right? I mean, we talk to kids about this all the time, right? May versus can, right? May here suggests like I'm giving you permission to exercise a power that you've got.
Because, if I may answer the question, every other delegation under the Maryland Code, in fact, in the federal code, it uses that exact same language. There's no other delegation in the code of the power of eminent domain to a power company, other than right here. And if you look at the other utilities that are in the Maryland Code, there's the oil pipeline corporations. They use identical language, which is that it may acquire by condemnation in accordance with Title 12 of the real property article. That's how a gas company gets its power of eminent domain. That's how an oil company gets its power of eminent domain. That's how a water company gets its power of eminent domain. That is a language of grant. And even in the
Thank you,
Natural
Councilman.
Gas Act, that's the same may acquire is the same language used for a grant.
Thank you.
Thank you.
Mr. Wyan?
Your Honors, Harris Eisenstein, just briefly, I'd like to address Judge Wilkinson's practicality argument first. As my colleague acknowledged, this transmission line will not be built by the middle of 2027. So the predictions of what's going to happen then become now reality. And as we briefed and as we presented to the district court, there are contingency plans that are in place right now to make sure that the predictions of brownouts and blackouts and all these terrible things happening in Maryland don't actually happen. Those contingency plans include keeping alive 2 very large generating facilities in Anne Arundel County. In addition, and perhaps even worse, this particular transmission line, in order for it to provide electricity to anybody in the state of Maryland, it needs to hook up to a substation, which is in sort of western Maryland. The only way it does that, it's called the Dobbs substation. The only way it does that is if Dobbs is upgraded. And there was evidence before the district court that provides that the Dobbs substation will not be upgraded until 2030 at the earliest. So these predictions of this imminent and irreparable disaster are not actually reality.
That's a policy question, and that's for, with all respect to you and the panel and everything, we are not especially well-versed in making an informed prediction as to when the blackout concurs or is likely to exist. There are certain times when a federal court actually, Chevron notwithstanding, can defer to the expertise of the people who have the expertise. And I intend no disrespect for you or me or anyone else, to say that the expertise is not lodged right here between us.
I don't purport to be an expert on generation, Your Honor. All I wanted to represent to the court is that in the record, it is clear that there are contingency plans that are going to protect Marylanders. And if I could back up with my last 50 seconds, on the balance of equities, as the court has acknowledged, they have to check every single box. On the balance particular, it's our position that this preliminary injunction is a credible and prolonged threat of condemnation. It says by its express terms that access is for, quote, acquisition and future use of the properties in connection with the Maryland Piedmont Reliability Project. It doesn't say that they might acquire it or that they could acquire it. It says for acquisition and future use. That looming threat is a multi-year cloud on title. It's going to extend at least through the CPCM process. I ask Your Honors, who would buy property earmarked for future acquisition in connection with a high-voltage overhead transmission line? The answer is no one. And yet, PSEG is not paying just compensation. There's no promise of just compensation. The preliminary injunction does work a taking on our clients. And for the reasons we've briefed, we would ask that the preliminary injunction be vacated.
Jay, do you have any questions? All right, thank you. We'll come down, we'll greet counsel, and appreciate both of your arguments. We'll take a brief recess.
This honorable court will take a brief recess.
Please be seated. All right, we'll start with our third case, and Billsden versus Wells Fargo. And, Mr. Petrani?
Thank you, Your Honor, and may it please the court. Plaintiff Christopher Billison worked at Wells Fargo Securities for decades, all while suffering from a paralyzed bladder and colon. He was laid off, along with over half the sales managing directors in his group, due to COVID-exacerbated cost pressures, not discrimination, and none of his three claims can support the judgment to the contrary. First, his failure to accommodate claim makes no sense. He was working from home during the entire relevant period, and his requested accommodation was, in fact, to work from home. Second,
Wait, just on that, wasn't his requested accommodation to work from home when everybody else was no longer working from home?
well, yeah, Your Honor, we're not doubting that there would have been a question at some point as to whether the parties could come to an accommodation down the line, but as of late December, there was no go-back-to-work date.
But there
And so-
had been earlier, right?
Yeah, so there was a kind of a stop-and-start sort of process. They
Yeah, I
kept.
remember the time. There were lots of stops and starts.
Yes, I mean, this was very common. I think we all remember this. There were a lot of businesses that said, we're going to try to go back to work, and then there was the Omicron variant, or something else happened where then they delayed it yet again. But the key point here is, during the entirety of his time with the company, he was able to work from home. He was also reassured that he would not have to stop working from home as long as he had an outstanding accommodations request. And it just so happens, of course, that he never ended up needing an accommodation. But I think that,
Wasn't he told that actually his request was closed, that he would have to re-up his request once there was a return to work order in place?
yeah, so Wells Fargo decided that it
And he
didn't.
didn't work from home during his entire 25 years of working there.
No,
You-
that's certainly
you-
the case,
You just
Your
said he
Honor.
worked from home
Well, I was-
during his entire period.
No, I said, well, I hope I said the entire relevant period. If not, I just misspoke. But my point here is that during the entire period in which he was requesting this was in fact the work environment that he had.
So you frame this as like a merits question? Why isn't this like an Article 3 concrete injury problem? So, the thing he requested, the accommodation, I take it to be to work from home. We don't think about accommodations relative to other people. It's like, what can you do? And so I guess I have a little hard time understanding what the concrete injury is on this claim. Like,
Yeah, so
help
Your
me
Honor-
understand what you,
Well, so Your Honor, we don't think there is any injury, of course, and we think that there's two ways that Your Honor could look at that. I mean, one is, much as the 11th Circuit in Batson explained, that means that claim just doesn't exist. You can't have a claim for basically an intent to deny a future kind of hypothetical accommodation, or you could say, I mean, we haven't made this argument, but you could say there just is no injury from an Article 3 perspective, and we certainly wouldn't, object to that. I don't think necessarily you have to go there. I think you can just say this kind of a claim, it doesn't work. The 11th Circuit laid that out well.
well, we can't actually do that, right? We can't sort of assume jurisdiction and just say it doesn't work, right?
Well, I
That's
do
a
think-
that's
well,
a
I-
Steel Co. problem.
No,
So
no.
it seems like we have to answer the question of, was there a concrete, imminent, and particularized injury, right, such that it like satisfies TransUnion's test, right? There might be a congressional cause of action, but in this instance, it's hard to see what the injury is. I'm saying that I want to work from home, and I'm currently working from home, and I'm indefinitely allowed to work from home. I don't know what the real-world injury is in that
Well,
context.
I'm not going to disagree with Your Honor on that point. My only point was.
I didn't think you would,
My only
but-
point is that I think these are both sort of threshold questions, whether this claim even exists at all. But I'm not going to say that there was an injury here that the court necessarily has jurisdiction to address. I just think even if the court says that there's at least that level of alleged injury, I don't think that this claim works. I think this court's decision in Myers reinforces the directly on point Batson decision in the 11th Circuit, where this court made clear that accommodations are about like the present or immediate future. We're talking about like right now. What do the parties have to do right now to accommodate a potential disability claim? And this is not that. I mean, this is at best, at absolute best, a completely far off kind of hypothetical, maybe at some point
But
we'll
is
get
it
to
really
this.
maybe at some point they'd already been ordered to return to work? this man is sitting at home not knowing what day folks are going to be asked to return to work or how long the return to work will take. He's been engaging in this interactive process for what seems, I think, from the record to be months. And rather than be told yes or no, you'll be allowed to stay home once others are required to go back, he's told your case is closed, come back to us at the relevant time. And so it's actually not indefinite because Wells Fargo didn't announce that there was an indefinite stay at home. To the contrary, Wells Fargo had called everyone back and then called it off. And I think my understanding is people did go back to work a month after he was terminated. Isn't that right?
Yeah, I do think it was about a month after, but to be clear, when I said it was indefinite, what I meant is in late December, when they decided to close the case, at that point, there was no date for going back. They didn't have a determined, here's the date where we're going back. And also to reiterate, they also made clear, as long as he had an outstanding request, they were not going to require him to come back into
I
work.
think what he's claiming here is that any arrangements that were made were provisional. That he's, and I'm not sure how this spools out in my own mind, but it seems to me he's saying, well, you didn't formally accommodate me, and you didn't engage in the interactive process that is necessary as a prelude to accommodation. And so he's saying that the statute, when it says accommodation, is talking about some form of assurance that this will be here as a more or less permanent matter. I mean, I think that's what he's trying to say. Well, that's what he's contending, that there wasn't that any accommodation here was not an accommodation, it was just a matter of happenstance. And that all the indicia of accommodation were absent. Now, what do you say in response to that? I'm not sure whether or not that's persuasive, but what do you say in response? Because that seems to be the nub of what this gentleman is contending.
Yeah, Your Honor, the text of the statute is you can't fail to make, well, the gerund form, making an accommodation. So already we think that tells you it's kind of a present tense, or at least close to present tense sort of thing. That's also what this court said in Myers. So I don't think that you can basically say, well, I want this assurance that 3 months down the line or 6 months down the line, something is going to go the way that I want it to. And then when it turns out that it never actually ended up being needed, you can just point back and say, well, you didn't give me a formal piece of paper that says I would have gotten that. I mean, I think two hypotheticals just show that this can't possibly be right. One is take this very case, but imagine that he was not laid off. And then they did decide to grant him an accommodation, maybe not the exact one that he wanted, but suppose they granted him the exact one that he wanted. He could still somehow claim that they failed to accommodate him because back in December, they had not formally granted him a letter at that time. That doesn't make any sense. Or imagine someone in a different circumstance asks for an accommodation for an event 6 months down the line. The accommodation is formally denied. They say, we're not giving you this accommodation. But then 3 months later, that person's entire division is laid off, and there's no question.
Why would it be difficult for you to simply sit down with him and saying, what do you need as an accommodation? And
Well, to be clear, Your Honor, we think that that's exactly what was happening here. I think if you look at Davis's notes and if you look at the testimony, when they decided to close the accommodation request, it was very much still in the balance what kind of accommodation might be sufficient for him and what kind of accommodation Wells Fargo could provide for him. So just to
But
give...
they closed the request. And, I'm sitting here very cognizant of the fact that we're after a jury trial and a jury conclusion, and it just strikes me based on the evidence that a reasonable jury could have concluded, based on the evidence, that the fact that he was terminated before he needed it did constitute a refusal to make the accommodation. I mean,
Your
I
Honor-
think about having an employee, for example, who's deaf and says, I need an interpreter, or I will need an interpreter when I have to do something in the future. And the employer, rather than saying, okay, we'll get you an interpreter when you need it, simply says, come back to us at the time when you need that interpreter. Wouldn't that be a refusal to accommodate, and isn't that exactly what happened here?
Well, Your Honor, I have a factual and a legal response. So the factual response is I don't think any reasonable jury could come away from this saying they had absolutely denied any sort of accommodation. I think the evidence is unequivocal that they were still trying to figure out what kind of accommodation they could potentially provide when the time came. But legally speaking, there are other claims that address different problems. So Batson makes this point explicitly. So in this case.
Can you make, you're running low on time, and I'd like you to respond to what I think is your hardest line, because it seems like to me you sort of got to run the table here to get what you really want at the end of the day. With respect to the retaliation discharge claim, tell me why, given the temporal connection, which is there, as well as the evidence the jury was presented with respect to the dislike and disdain for future work from home. I get you have evidence on the other side of that, but there's some evidence the jury could find that his managers here really disliked the work from home process. Why isn't that enough for a jury to conclude that the retaliation discharge claim didn't require a JNOV?
So, Your Honor, just briefly before I answer that,
Yeah.
on the disability discharge claim, that is where the North.
Yeah, but I'm trying to get to this piece.
No, I understand. The only reason, I just want to quickly mention that we do think that if the North Carolina claim goes out, that has specific effects on its own. So I agree with you that on the federal side, we need to run.
I get
the
it
table.
does on the
Yes.
back end, maybe if you preserve the equity argument, I get it. But
Yeah,
I'm
but-
trying to get to
yes.
this question.
So, first of all, I think that on the proximity piece of this, I think there are two huge problems with the notion that this is proximate. The one is there was unrebutted, uncontested, unimpeached testimony from 3 different people that Billiston was already being considered for reduction in force by
Yeah,
the
but they had
summer.
chosen not to until he made this request, right? I understand, that's a great jury argument, totally get it, right? But you might just think about it the other way, is that they were considering it. They decided not to until he made this request, and so then they retaliated against him.
Well, on that point, Your Honor, I don't think anyone can seriously deny that there was a serious downturn in this group's fortunes in the late summer, early fall. I don't even take, and we can see what opposing
All
counsel
right,
says.
fine, but that just says you're going to fire somebody, right? It doesn't say who you're firing.
No.
And if they chose him out of the other options because of, but for, his, request, not his disability, I get that's a different issue, but because of his request, it seems like a jury could make that conclusion.
Well, Your Honor pointed to 2 pieces of evidence. The first was proximate temporal
Yep.
relation. And on that point is, the unrebutted testimony is that there were 3 names. It was Fitzhugh, Billiston, and Abley, and that Iannuzzi pushed back on Abley. So Fitzhugh, they then did add to the reduction in force, and then the only other name left at that point really is Billiston. So that's all before you're getting to the time of the supposed retaliation. But the other point, your evidence-
the first time they didn't include the plaintiff.
No,
Right? He
that-
wasn't included.
No, that's true, Your Honor. I mean,
Right?
the
And a
business-
jury could conclude
Yes.
that they made a decision, that wasn't an accident, it wasn't a Scrivener's error, that they made a decision to not include him. And then there's a complaint about an accommodation, and then he gets included in what might be viewed as like a little bit of a procedurally odd way.
So, Your Honor, I don't think it was terribly procedurally odd, but I also think even if you buy.
I didn't bring that up as the start, right?
Yeah.
But we still have this sort of animosity to work from home.
Well, but so 2 points on that, Your Honor. I don't think that I would deny that they didn't like the idea of working from home, but I don't see how that leads into sort of a retaliation kind of a claim. Like, I do think you can infer from these notes, they were not a fan of the idea of working from home, but I also think the only thing you can get out of these notes and the surrounding evidence is that they were looking for alternative solutions, and that they were still looking for alternative solutions when they ended up putting him on the reduction in force.
And you think the only thing a jury could conclude, given this temporal and this dislike, is that? That seems like that's a really lenient version of a JNOV standard,
Your
right?
Honor, I don't think it's a lenient version. I think you just have to actually look at the notes themselves. I think if you look at the way that Billiston is characterizing them, maybe you get a different conclusion. But what the notes show is Wells Fargo doing what it's supposed to. And I actually think it would be incredibly dangerous for this court to say that engaging in the interactive process, saying, well, we don't really love this idea, but maybe we have this other alternative idea, If that's somehow on its own, combined with, temporal proximity, although for the reasons I've suggested, I don't think that's a particularly strong argument here. If that's on its own enough to say,
Yeah, but when
okay,
you strip it down to its essence, why wouldn't it be like this? Among the various options that the company possessed, whether to lay off employee A as opposed to employee B or C, or whether to lay him off at all, that the request factored into that. I mean, I think it's a trickier argument to me to say that there was a failure to accommodate when he was on remote work during the entirety of his employment. But it occurs to me that the retaliation argument is a little bit less tricky and a little bit more straightforward, and by saying that given the temporal connection, the fact that he had a request pending really annoyed the supervisors, either because they didn't like remote work or because, or whatever, but that request sufficiently annoyed them that they took this route among two or three others that they could have pursued. And, you do have a jury verdict out there, and it's kind of hard to say that this person's request didn't factor in. You can just see people sitting around the table and say, well, we got this request out there for remote work, and that's just not a good idea. We don't like that. It's against really the company is trying to come back from COVID and do that, and then you say, yeah, well, and they only needs, the problem is, and Judge Richardson says, you really need to run the table to prevail in light of the jury verdict. You've got to prevail on all of it to overturn the verdict, I think. And of the different claims, it seemed to me that you had a relatively stronger point to make with the failure to accommodate, but that it was a little more difficult for you to undercut the retaliation claim by saying that this request for an accommodation did not factor in at all or played no part in the company's choice of options. That's what's hard.
Your Honor, my time has expired, but if I could briefly respond. So just quickly, we do think if we win on the disability discharge claim, at least the North Carolina punitive damages go away. We also have arguments on damages. But just to respond to Your Honor, I do take Your Honor's point that there is an argument for temporal proximity. We obviously have made our argument that we think that under the law you can't just ignore the unrebutted testimony to the contrary. But even if you think that there's temporal proximity there, and from there, to some extent, that is, evidence in favor of retaliation, I don't think that temporal proximity alone is sufficient. And I think if you really drill down into all of the sort of plus factors that Bilston tries to provide, none of them ultimately get where he wants to go.
Why isn't that a jury argument that you've just given us? I mean, yeah, I get it. I think those are really valid points to make, but how does that justify overturning the jury's verdict on this point? Because what you said is a good argument, but it's maybe a better argument before a jury than it is before us.
Well, Your Honor, I think the idea that temporal proximity alone cannot provide enough evidence, we cite cases in our briefs saying that on its own is not sufficient. And so my point is just that even if you think that a jury could look at the evidence on temporal proximity and come away with the idea that, yeah, this was sort of temporally proximate, even though they were still trying to accommodate him, they still had an open process, et cetera, even though they talked about this in the summer.
But you can look at the fact that the request was still pending at the time that the decision to lay off was made. It's not just temporal proximity. I think it's the point that the request for the accommodation was still pending when the RIF decision was made. So I think in characterizing it as purely a question of temporal proximity, I'm not sure I'm not sure that's the only factor that weighs in here.
Well, Your Honor, that's certainly our position, but even if Your Honor disagrees and thinks that maybe a jury theoretically could, maybe there's enough evidence to
Well,
at
that's
least
not
get you to the
theoretically,
point.
they did.
Well, sure, but the analysis, the question is, first, judgment as a matter of law, is there sufficient evidence? And then the second argument is, of course, a Rule 59 weight of the evidence argument, and I think there, at the very least, the weight of the evidence is overwhelming, and we would point to the district court's attempt to justify not vacating the jury verdict, made basically 3 claims, and all of them, we think, were just objectively
All right, but
false.
you do recognize you need to prevail on all of them to overturn the jury's verdict.
Oh, yeah, yes, to at least
Can
with
I
the
ask a
federal side
follow-up
of
on
things.
that
Yes.
question? So, except the hypothetical, it's purely hypothetical, that this court decided to vacate the failure to accommodate and the disability discharge claims, both state and federal, but we affirm the retaliation discharge claim. And assume for a minute that we agreed with your back pay argument. Tell me what we would then do. In other words, you now have only ADA claim that is left. In general, that would be an equitable judgment to be made by a district court. You have not exactly argued, either to this court or to the district court, that the court was required to make separate findings with respect to this retaliation discharge claim. Why aren't you bound by the jury verdict on the front pay, and back pay piece, subject to the substantive arguments that you've made?
Well, on the back pay piece, we made our arguments as soon as we could when we got a back pay damages award.
But not that the judge should be the one determining the ADA equitable piece.
Well, and to be clear, on back pay, our argument has always been a legal argument, not the argument that this would be on the equity side of things. Now, I do think on the front pay side of things.
So you agree, if, in my hypothetical, where we did those things, the $4.7 million award for back pay, we would affirm as a jury's award?
Well, it was $6 million, and we think it should have been at the very least no higher than 4.2, but.
I thought it was 4.7. Whatever the reduced number that you argued.
Yes,
I thought it was
4.2 is the
4.7
argument.
or 4.2, whatever it
our
is.
argument, Yes.
Whatever that number is, we would affirm that as a jury award of roughly $4 million in back pay damages.
Yeah, we would ask for the court to either order a new trial on damages or
A remitter.
a remittitor. But yes,
But with
we're not
respect to
contesting
front
that
pay, even in my hypothetical, you're not objecting to the fact that the jury was the decision maker. You're objecting to the result that was reached, and there are a number of substantive arguments, but you're not asking for a remand for the district court to determine front pay damage.
Well, Your Honor, actually, Billiston specifically argued in his brief.
What, can you ask the question first? So are you asking for a judicial determination of equitable front pay?
Yeah, we do. So we did ask for this post-trial, that it should have been a judge question. We do think that makes more sense. The reason that it was sent to the jury in the beginning is that North Carolina law, there was some lack of clarity, but it seemed like possibly this should be a jury question, and so maybe it goes to a jury.
Didn't you ask specifically that the front pay argument be decided by the jury? Aren't you stuck with that?
Your Honor, I don't think that we are. I think that we were agreeing that the North Carolina side of things could probably should be decided by the jury. I don't think that we necessarily were, agreeing to everything, but regardless.
But you didn't ask the district court, after the jury verdict came back, it seems like to preserve this issue, you would have said, hey, district court, you may consider this advisory with respect to the ADA claims, but your responsibility is to enter, an equitable judgment that, conforms or doesn't conform with what the jury determines. And you don't get double recovery, but you would need the district court to make those findings. You didn't ask for that. So it seems like to me that issue is waived for us. We're sort of bound by what we've got.
Well, Your Honor, my recollection of what we asked for is that the judge should have decided those claims to begin with. I don't think we made this specific argument that you should now enter a judgment separately. Thank you, Your Honors.
Gessner, we'd be happy to hear from you.
Thank you, Your Honor. May it please the court, Wells Fargo's appeal asked this court to overturn a unanimous jury verdict after a full trial. But under Rule 50,
How long did the trial go on?
it was a week. It started on a Monday, and the jury rendered a verdict around 3:45 on Friday. And based on the evidence that the jury heard, the full evidence during that week, a reasonable jury could reach the result this jury did, based upon the record that it saw. This is by far not a no evidence case. The jury heard and saw a full record, including the accommodation process, Wells Fargo's own human resources documentation, contemporary notes of that process, Wells Fargo's response to Mr. Billiston's disability-related limitations, and the late development.
But he had the accommodation he wanted during the time that he worked there.
That is incorrect, Your Honor. At the time
Is
that.
that correct?
It is not correct. He had asked for
Why
Wells Fargo had announced a return to office. He then formally asked for a concrete accommodation to be able to work from home when the employees were returned to office. And as we talked about, and as Templeton, is in the record.
Does it turn on that? Is your point that there was no accommodation, that accommodations are relative to what other people are getting? So if I'm seeking an accommodation that everybody else is getting, that they must separately provide it, right? I mean, we don't normally think of accommodations as relative to somebody else. What we say is, what do you get to do? And here, he was getting to work from home, and there was no end that was established for getting to work from home. And so I guess I don't understand this attempt to tie it to when other people come back. The answer is, he said he needed to be at home. He was at home.
Your Honor, the difference is the Americans with Disabilities Act. He had an imminent need, and that imminent need.
What was the imminent need? What was imminent?
Wells Fargo kept, using the records words at JA 934946, that they were, that the return to office was imminent. It was fits and starts, is what they testified to. So what happened is, in August of 2021, when he first asked for the accommodation, Wells Fargo said, everybody's back in the office. They kept moving
Do you agree that
goalposts.
it requires it to be imminent? I mean, do you think that's the right standard? So if the return to work was imminent, so at that point in time, and I understand your suggestion that you thought it was, but if I disagreed with that premise, that there was no, at this time, in, whatever it was, December, there was no scheduled return, and therefore there was no imminence, do you agree then that there's no injury?
Not at all.
Okay, tell me what you think the injury is if you accept, I understand you don't, but if you accept that the return to work was not known or imminent. What would your Article 3 injury be?
Because the managers had already rejected the request to work from home.
I'll accept that, okay, and why did that injure your client? Why was that a concrete and particularized injury such that it satisfies TransUnion standing requirement?
Well, first of all, Wells Fargo has waived any arguments because they didn't make any.
It's jurisdictional, you can't waive it.
And
So
second.
go to second.
That wasn't this case. Again, he had.
What do you mean that wasn't this case?
Well, the jury
I've
heard-
asked the question is,
Sure.
what was the injury to your client?
That he was going to be forced to return to work without a solution for his bathroom needs. That there was never a
He
indefinite.
was going
work
to
from
be,
home.
okay, that's what you think the injury is, though. That's what I'm evaluating for Article 3, is the risk that he might be returned to work without a solution.
Well, and the jury heard, Your Honor, that it was a real risk, and it was a risk that was causing great emotional distress. How am I going to go to the bathroom when I return to work, which is imminent? It was coming around the corner. In December of 2021, at the time that they tell him, again, what is very clear, I'd like to impress upon the court, is along the trial theme of the case, they said, we had gone through all of the hoops to see if we can accommodate him, and he was already being accommodated, so therefore satisfied. But at appeal, they've argued, we didn't go through all those steps. Instead, we tabled that because he was working from home indefinitely. Those are two very different things as to what was happening. The tabling
But
of.
neither of those matter to my, I'll just give you one final time, and then
Yeah.
I'll stop. Neither of those matter to my point. What I'm trying to just make sure I understand, if they tabled it or if they denied it outright, right? Tell me just one more time why that was a concrete injury to your client.
The concrete injury to Mr. Bilston was not having an answer to his bathroom need and knowing that he was going to be required to come to the office. So again, it wasn't as if.
How did he know he was going to be required to come to the office? Because he sort of understood that COVID was going to run its course?
Well, Wells Fargo had been announcing from August of 2021 all the way through until February of 2022, monthly, their return to office dates. It is a moment in time in December, which they say in their briefs, when Omicron hit, and everybody thought, oh no, we're going to go back to everybody from home. But it was very short-lived, Your Honor. By mid-March of 2022, less than a month after they fired Mr. Bilston, they're back in the office. So it
When did they
wasn't
announce
imminent.
that return?
That return was announced, I believe, February 9th.
But
So-
the question is something a concrete injury? And let's say we can say he was accommodated, maybe not ideally accommodated, but he was accommodated during the entire period of his employment. All right, so we get to the question of whether there's an injury, and all of the Supreme Court's case law has said there has to be something concrete. It can't just be a theoretical injury. And you say, well, he was worried about what the situation would be once COVID had passed and people were to be required. But we can all speculate and worry about what may or may not happen in the future. And I'm just wondering whether that kind of concern, I mean, every single human being has worries about what the future, how the future may unfold, okay? But that doesn't necessarily make a worry about the future course, concrete. It has to be something a little bit more imminent than that in order to count. And all I'm saying, hold on for just a minute, I'm interested in listening to you, but I have a question here, and that is, isn't the fact that he worked from home during the entirety of the period of employment, doesn't that make the ADA claim, particularly, I guess, in light of the 11th Circuit decision, which seems to me awfully close, doesn't that make it a trickier path for you than the retaliation claim? And if you prevail on the retaliation claim, is that the whole ballgame because the jury's verdict would be upheld?
May I answer all of those, Your Honor? A couple things. Let me start where you ended.
I'm just asking to boil it down for you.
Okay.
Why isn't the retaliation claim a surer path for you than the ADA claim? You might concentrate on the retaliation claim. And does the retaliation claim preserve the judgment for you, subject to the substantive arguments on back pay and front pay?
So let me start and respond to that with citing to JA 1266 through 1291. Wells Fargo itself treated the need for an accommodation as imminent and as harm that would be caused to him if it was not given. Mrs. Davis, the Human Resources, detailed in her notes the numerous meetings that they needed under the ADA to give him a prompt response. Return to office was around the corner. And the only time that it was no longer imminent or no longer being pushed was after the decision to terminate him had been made. So all the way up until December 6th, the day that they decided to fire him, that was undisputed, they were all working towards this imminent return to office need. And those notes detailed day by day, talking to the managers, getting their no's. Manager told, the jury saw the notes where the managers tell HR, no, we're not going to accommodate him. She says, try it for 6 months. they say it's just delaying the inevitable. They say, well, let's see if we can give him 2 seats. She doesn't even go tell Mr. Billiston they want to give you 2
How
seats.
is your decision, how does it differ from Myers v. Hose and also the 11th Circuit
Well,
case?
yes. So in Batson, Your Honor, under the 11th Circuit case, that case is very different than this case. In that case, Batson admitted that she had never been denied an accommodation. That isn't this case. Mr. Billiston, all along, never got an answer to his accommodation request before they fired him. In addition, Batson was on summary judgment, so the burden was on, the evidence was looked at in the light most favorable to the plaintiff, and the plaintiff admitted that she had not had been denied an accommodation. In addition, that's why we've cited Roberts out of the 10th Circuit. The Roberts case says that you can't just reject and wait until harm happens. You have to follow the ADA and make a timely accommodation for something that's in the near future. And there's lots of instances where people are expecting something needed in the near future, just as Judge Werner had given the example regarding a deaf
What
employee.
about the Myers case?
Well, in the Myers case, Your Honor, that case, it says no duty for an indefinite future accommodation. This wasn't indefinite. This was a return to office that was imminent at all times, actually happened, and that the only time it didn't become imminent is when they had already made the decision to fire him. So to argue that it was tabled or it wasn't imminent or he was being accommodated the entirety of the time is just not the record of the case that the jury saw. The jury saw in the notes that there was heightened scrutiny
So you're
over his
saying Myers
request.
turned on imminence and
Right.
and this is imminent here.
Well, Myers says, no duty for an indefinite future accommodation. And here, it was definite. It was a return to office was coming. And may I, Your Honor, address your question about retaliation versus disability discharge? A key point in the record is that Mr. Billiston's disability changed over time. And if you look at that same site, Mrs. Davis's notes, the managers immediately asked,
But
what
didn't
changed?
change was his request for an accommodation, and I thought your retaliation claim was simply that it was the request for an accommodation that factored into the discharge and that was retaliatory.
Well, the evidence for both the disability discharge and the retaliation can overlap, and there was overlapping evidence that the jury saw. The first point is that the managers, Wells Fargo claims the managers knew he had this disability, but when, in her notes, they're asking
But I'm
him,
asking you, suppose we were to uphold you on the ground of, on the retaliatory discharge, okay? That preserves your judgment, or are you nervous about that?
No, I'm not nervous about that. You are to believe that this judgment can be affirmed in multiple ways. It can be affirmed by upholding the jury's full verdict as is. It can be affirmed by using the state law claims under WDPP. It can be affirmed by a disability discharge claim standalone, and it can be affirmed under a retaliation claim. So there are 4 ways.
Can I ask the last question, which is the retaliation? If we hypothetically, if we only affirmed on that basis, that would eliminate the state law punitive claim, the $1 million state law punitive argument, is that right?
Well, that's what counsel had just said. Again, we disagree with that. Again, the jury returned a verdict. Are you saying hypothetically, again, which we would disagree with, that you overturned the jury's verdict on all claims except for the retaliation?
Right, that's the point. That's the hypothetical, right? I
Okay.
understand that that's not what you want, and I understand. But I'm just trying to understand what the world looks like. If that were to happen, that would mean on the disability discharge state law claim, there's $1 million punitive award that would go away because that claim would have been overturned,
Okay.
right?
I'm sort of
you're not-
following you.
Okay. And then we would ask the question with respect to back pay and front pay that we have to ask regardless, whether they're substantive arguments about the propriety of those is correct or not, but that would be the only question that we would then have. We would get rid of the state law claim and that punitive. The punitive on the ADA would remain, the front and back pay would remain, subject to the to the defendant's arguments about the size of those verdicts.
Well, and obviously, Your Honor, we would disagree with that finding because the jury
This
had
is
an
why it's a
abundance of
hypothetical.
evidence. But in
This
that
is why it's a
hypothetical, again, standing here today, there wasn't a separate retaliation claim under WDPP that allowed a separate recovery
Okay.
for the back pay and front pay under WDPP. Whether that allows punitive damages to go, I honestly don't quite for sure know, because under North Carolina state law, which Wells Fargo did not brief, there's only a cap. It's $250,000 or 3 times compensatory. The question would be, are those compensatories that are given under a federal claim part of the cap?
But
So I don't
if
think
we,
it would be.
vacate the state law judgment, we have to vacate the entire state law judgment.
I disagree with that. I don't think that you can have, I don't think that you have to have compensatory damages that you have elected. Think about an election of remedy, that you have to elect the state law
You think you can get
damages to get
state law
punitives.
punitives based on a ADA claim?
Well, because they could find that they didn't meet the underlying compensatory and they did meet the punitives. It would be capped under North Carolina law in that instance at $250,000. But the argument that if the retaliatory verdict was upheld, and the punitive damages, the jury had a separate line. Did they willfully violate North Carolina law, yes or no? If so, how much in punitives? So the punitive damages were a separate claim that they were allowed to award, and those punitive damages under state statute are only capped by the amounts of the award. What I'm unclear on is whether it has to be only that you elect under WDPP in order to get punitives. I don't think that that's accurate, Your Honor. And may I address damages while I'm up here for just a minute, Your Honor? Defendants argue in back pay that there was not enough evidence to support the number that the jury rendered. That's just not accurate. It's not a single number case. The jury did not hear a single back pay number from the expert. That Mr. Billiston's compensation
You
was-
don't think he said, whatever the number is, your argument is the 4.2 number, your expert, Mr. Moore, never said it.
He did not say it. It is not in the record. There was a demonstrative table that was shown.
But your argument depends on the word, like he didn't say the back pay is 4.2.
He did not. He gave a total cumulative damages at the end of his testimony only for the 32 million inclusive of back pay and front pay. In addition to that, he testified that his numbers were very conservative. They did not include deferred comp.
Let me just ask hypothetically, if we found that by testimony and reference, he said the 4.2 number, does that change, does that mean that you're limited to the 4.2?
No, it doesn't. I don't believe he said that, Your Honor, but
That's why it's a hypothetical.
Yeah, I do not believe that we're limited to that number. The jury wasn't limited to that number. The jury had multiple facets of his compensation to consider. As an example, Mr. Billiston's deferred comp, which was not included in the math, was 40% of his bonus. If you just look at that number for the back pay for 2 years, it's 1.8 million. No one was in the jury room. We don't know that that's the math they did, but that was evidence that was given to the jury that closes the gap on the 4.2 to the 6 million. It's almost precise. Wells Fargo takes issues with, I gave in closing.
Excuse me, counsel, why would the ruling on a claim like compensatory, like retaliation, which speaks, at a minimum to compensatory, but why are these punitive awards generally? What is the reason for upholding the punitive awards as opposed to making this purely a compensatory damages case?
Well, first off,
Because one could look at the company's conduct here and say, well, you have enough to uphold the jury verdict for whatever compensatory damages can be awarded, but I'm not sure that the company's conduct in its entirety merited a punitive award. So is it possible to say that, this is a company that, wasn't perfect, but it didn't reach the level of egregiousness that was necessary for a punitive verdict?
Your Honor, Wells Fargo never raised that on appeal. So there's a Rule 28 issue. It was waived. It wasn't raised on appeal at all, and the jury had enough evidence to find punitive damages. The jury heard evidence that at the highest levels of the bank were involved in this decision to terminate Mr. Billiston after he had disclosed his changing disability needs and his need for an accommodation. And so the jury heard an abundance of evidence of willful, reckless conduct in which that punitives were awarded both under the Americans with Disabilities Act and under state law. Under state law, it's a clear and convincing standard.
Your view of it is because the whole question of punitives wasn't raised, that we're bound to the jury's verdict on that point.
Yes, Your Honor. The same argument is true, too, on front pay. There's an argument on front pay. Wells Fargo has raised as a zero. If you change jobs after you have been discriminated against and fired, then you get $0 on front pay. That is not the law. And in fact, they changed their theory. At trial, they argued mitigation, reduced front pay. At appeal, they're arguing cutoff because he changed jobs. But I would point you to JA 1357, 1360, and 1367. It is important to note that Wells Fargo received double mitigation because Mr. Billiston changed jobs. He went from Breen at $250,000 a year to Academy, and he was credited in the mitigation chart of $500,000, if you compare 1360 to 1367, in the numbers that were provided by Dr. Moore in the demonstrative. In addition to that, the jury cut the front pay in half. The ask at closing was roughly $28 million, and the jury showed restraint and took in the evidence and issued a $14 million. And Judge Richardson, I think
That's
there.
restraint?
Well, Your Honor,
$14 million is restraint?
Well, I'm glad you raised that, Judge Wilkinson. Mr. Billiston brought into the bank over $60 million a year in sales. He had record sales years the last 2 years that he was there. We're talking about highly compensated individuals. They all made $400,000 base, and the delta between their pay was the bonus. His pay was.
Why would they want to discharge somebody who is that productive?
Well, we asked the jury was asking themselves the same question, Your Honor, because that is exactly one of the theories that the jury heard at trial, which is, here is this top producing, having two record years.
It would seem to me that whether somebody had a disability or not would be, I wonder whether that doesn't cut against you, because if it seems irrelevant. If somebody's bringing in $60 million in terms of revenue a year or whatever he's doing,
Well, and logically,
you would want to keep that individual on.
Logically, Your Honor.
Regardless. So why did they get? Why? I mean, just.
Yeah.
I don't understand if this individual was as productive as you just told me he was. Why would they want to discharge him?
Well,
Why?
it's in the record. In Mrs. Davis's notes, Jennifer Doyle, when she was confronted by legal and HR saying, you should try this accommodation for 3 months. Let's see if it works. She says, well, I have to weigh which is the greater risk, letting him work from home or not returning to the office. They were so adamant at the time to get everybody back into the office. They were willing to let go of somebody who was performing at the level Mr. Billiston was, just to avoid allowing him to have an accommodation to work from home. And the jury heard all that. The jury heard both sides. They heard Wells Fargo's story about how he was selected for the RIF. They heard the story about they knew about his disability all along. They also heard that the disability changed, the need changed. HR said he should be accommodated, and they rebut even their own HR person. The standards under Rule 50 and Rule 59 can be met by looking at Mrs. Davis's notes and the RIF sequence, the sequence in which that they opened up a closed RIF, put him in. The other very compelling email is once they found out they got away with it, once they found out that he was going to be gone by end of February before return to office, they were high-fiving each other, saying, there you go. And 10 days later, that was December 21st, 10 days later, they go to Mrs. Davis, HR, and say, tell him he's already being accommodated, and if and when he ever comes back to the office, he can try again. All of that, the jury heard, the decision had already been made, Your Honor.
So,
Okay,
thank you so much.
thank you. We ask that the court affirm the jury's verdict. Thank you.
All right, Mr. Petrani, you've got some rebuttal time.
Thank you, Your Honor. Many points, I'll try to get to them briefly.
On the punitive point, you didn't raise that.
No, our argument for why the North Carolina punitive damages award goes away is what Judge Richardson's argument was, or hypothetical,
But
which
that's
was.
not before us.
No, it absolutely is.
How
If
can
we
that-
win on the disability discharge claims, the punitive claim has to go away. I mean, I don't see how you can have a punitive damages award under North Carolina state law when there is no North Carolina state judgment. I don't see how that could possibly work. On accommodation, Batson is exactly on point. In Batson, the employee was specifically told her accommodation requests were denied. It's actually our case, which is even which doesn't have at the very least an express denial. But even if you want to say there was a denial, Batson did as well. I don't think there's any difference there.
And you don't disagree with Roberts as a principle, right? That if something is, you're going to have to travel in 2 days, that is sufficiently imminent.
No, we have not disagreed with the idea that if it's today or tomorrow, basically, and to be clear, in Roberts, it wasn't even just that he had to travel in 2 days. It was that he had to make his arrangements for the nursing assistant immediately, because you can't just do that as you go to the airport, as it were. On back pay, I find the argument that they never told a particular number to the jury baffling. On the one hand, closing arguments, this is specifically the number that they pointed to. The demonstrative from the report specifically points to this number. It shows the calculation. And if the argument is, well, actually, we never told them anything about back pay, that just means it's even more speculative. But there is no evidence from.
So your point is when he says, what is table 3, or what are the precisely the language? And he says, oh, this is the back pay number, right? The fact that he didn't use the words $4,223,762 doesn't matter, because by reference, he
yes,
is.
that can't be dispositive. And just to be clear, this was the evidence they put on about back pay. So if the expert came on and didn't say anything, which seems to be their argument at this point, then they just have no evidence on back pay. So that doesn't help them. And then just lastly on the 2 points on discharge and then retaliation. Hasn't been a ton of discussion about discharge. I think the Kelly case pretty much resolves that for us. But then on retaliation, there are a lot of things, and I think counsel for Billiston noted a few, where if you listen to the characterization that Billiston provides, it sounds a lot different than if you actually look at the evidence. And so I would just encourage the court, for instance, look at this question in the notes of how Doyle responded about the risks. This was not, oh, I am so worried about getting people back into the office because I think it's, it was FINRA. She was concerned about regulations requiring potentially people to be in the office. That's a totally reasonable thing to be concerned about. And you cannot draw the inference from that therefore she decided to retaliate. Similarly, this supposed high-fiving email, there is no high-fiving email. There's an email where someone says, once the RIF process was done, there you go. I mean, if that is sufficient, I think there's going to be almost no case where there isn't sufficient evidence to show this.
Wasn't there a Wells Fargo manager that testified that he couldn't recall a single time when a decision to RIF someone from Wells Fargo from start to finish was completed in 2 weeks? Wasn't it an unusual process?
I don't think it was an unusual process.
But wasn't there testimony
Yes,
from
so
a
this
manager?
was- so this
Excuse
was-
me, can I ask my question?
Yes. Sorry. I thought you had finished.
The testimony from the manager was that this was an unusual process and that they had never seen a RIF carried out in such short order. Is that correct?
Not quite, Your Honor. It's what I would say is.
At JA 976, that's not what the manager testified?
No, what the manager testified to was, the question was, this was Robinette, who had also testified that it was normal to add people to RIFs, et cetera, was that he had never seen someone chosen and ended up being done within 2 weeks. But that's not, I don't think that's the same thing, and I think it was pretty clear from the context that that Billiston was not just chosen 2 weeks before. The point was he had already been in the hopper, as it were, from the summer. So I think that is what He was, the question was not, have you ever seen a situation like this before? And then he said no. The question was an abstract question, not specifically about this particular circumstance. And he had already testified that this was an ordinary, there was nothing unusual about adding someone to a business case after it had already been done. The last point that I'll make, Your Honor, with 12 seconds left, is just, even if you disagree with us on retaliation in terms of no evidence from which a jury could draw, at the very least, we think the weight of the evidence arguments are strong, and we think that the district court abused its discretion in saying things that were just simply untrue about the notes, about witness testimony, in rejecting that argument. So for those reasons, we would ask the court to reverse.
Thank you. We'll come down and we will greet counsel and proceed directly into our next case. Mr. Rosenberg, you want to introduce somebody for us?
I do, Your Honor. I would like to introduce Zachary Warbaugh, who is a third-year student at the West Virginia University College of Law, and he is a qualified student who will present argument today, with your permission.
Look, very much look forward to hearing from him.
Thank you, Your Honor.
Mr. Rosenberg?
Good afternoon, Your Honors, and may it please the Court. In 2019, Mr. Hawley was sentenced to 127 months in prison. Now, the BOP and the District Court are taking the chance at transforming that sentence into a death sentence by denying Mr. Hawley access to the only form of life-saving care available for his condition, a kidney transplant. This Court should reverse the District Court's decision and remand with instructions to grant compassionate release for two reasons. First, because end-stage renal disease plainly constitutes a terminal illness with an end-of-life trajectory. And second, because even if not, the District Court abused its discretion by denying Mr. Hawley's motion for appointment of counsel and an expert nephrologist that would have helped the District Court understand issues its decision makes clear it did not.
Is your first argument, I understand the second one, but is your first argument that it's a per se question, that if you have a medical report that you have end-stage kidney failure, that necessarily means that you have a qualifying condition?
Yes.
No matter the scenario, that it's a just yes or no question, and if there's testimony that you have such disease, you qualify.
Yes, Your Honor, you qualify for extraordinary and compelling reasons. Now, there still is the limiting principle of the going through the 3553A factors. So it's not to say that anybody with end-stage renal failure or any end-stage organ disease automatically qualifies for compassionate release.
How is the district court supposed to make the determination whether it is end-stage renal failure versus something short of that?
Yes, Your Honor. It's end stage is when it progresses to stage 5, which is 15% kidney function. There's no dispute here, and the government does not dispute. On the record, or on the Joint Appendix at 94, Mr. Hawley does.
And why do we know? Why do we know that that's what this policy statement was getting at?
Well, Your Honor, in 28 U.S.C. Section 994T, Congress directed the Commission to, quote, describe what should be considered extraordinary and compelling reasons, and to include criteria to be applied and a list of specific examples.
And do you think, given the guidelines sort of nature these days, that a district court is bound by those, that effectively the agency here has dictated what the statute means by extraordinary and compelling?
Yes, Your Honor, and Amendment 814 to the policy statement, which was passed November 1st of 2023, made it binding on the courts. The government cites to many cases before that date where the policy statement was not binding to people in Mr. Hawley's position, but it changed. And here, under the policy statement, the Commission lists 4 per se qualifications: metastatic cancer, ALS, end-stage organ failure, and advanced dementia.
Maybe my question is, let me just ask it and then I'll stop, let my colleagues, but how is it made binding? I mean, the guidelines aren't binding on anybody, right? I mean, we live in a world where the guidelines are never binding on anybody. They might be procedural requirements. How is this one binding when none of the rest of the guidelines are binding?
Your Honor, Amendment 814 made it binding on the court. Prior, it was only binding as to BOP filed motions, but Amendment 814...
No, but my point is sort of a broader one, that, the guidelines the Supreme Court held are not binding as a general matter. Why would the policy statement here be binding when the rest of the guidelines are not binding?
Well, Your Honor, Congress delegated that to the Sentencing Commission under 28 U.S.C. Section 994T, and other courts have recognized as much, and the government has conceded as much in other cases.
But I'm not sure that they can concede that we defer to the Sentencing Commission any more than we defer to any agency about the meaning of extraordinary and compelling reasons. Like, that seems like a legal question, right? They've given a view about it. Why post Loper Bright, and given the non-binding nature of the guidelines, why do we think about this as being a binding question?
Well,
Maybe
Your Honor,
that's
the
my
ultimate
point.
question is still discretionary. It still may for compassionate release. But the argument here is that he qualified to have his case heard on the merits here. And if the district court would have found that the 3553A factors didn't weigh in his favor, then they still have the discretion to deny it. They never considered them. But as other courts in this circuit, United States versus Solis and the Western District of Virginia held that end-stage renal disease is a per se qualification under the policy statement.
Why would that be? I mean, I don't understand why we don't approach this whole situation on an individual by individual basis. I mean, there are questions where maybe someone has renal disease, but they're responding well to treatment, and then there are going to be situations where someone has renal disease, but they're not responding well to treatment, and you could find in one case, the district courts are splintered all over the place on this question. And the fact that the district courts may be reaching different conclusions on the matter may have more to do with individual factors that influence them. And I don't understand why, if someone's cooperative with treatment, that might be one thing, but end-stage renal disease, it encompasses a wide universe of situations. How old is someone? How well are they responding to treatment? And it seems to me that this process, when you read the statute, was designed to be one that gives the district courts considerable authority, because these plays to the district court's strengths, which are that individual the circumstances may play a big role in the result. And if we try to take this process from one where we respect what the district court has done and transmute it into a bunch of per se rules, it seems to me we're heading in a direction that's contrary to that which Congress intended. You might even find it backfiring on you in a situation where the district courts had ordered compassionate release, not just in this situation where they declined to order it and you don't like it, but there are going to be situations where the government's not going to like what the district court does that. But if you have a deferential standard of review, that works in favor of a criminal defendant or a particular inmate. So all I'm saying to you is that your argument can cut two ways. And there are going to be a lot of situations where the government's going to be unhappy about it, about a compassionate release situation. And if we're bound by a bunch of per se rules, and the like, and there's no deference given to district courts, we say, fine.
Well, Your Honor, I would disagree with the point that this is undermining congressional authority. In fact, I would argue what the district court did was undermine the congressional authority presented.
The district court looked at this individual and at the individual characteristics and whether he was complying with treatment and how well he was responding to treatment and what the situation would be in terms of the treatment accorded at the facility versus what the treatment would be accorded outside the facility. But all of this can turn on a bunch of individual determinations. And I think it's a path that's contrary to gall to take this and transform it into a bunch of per se rules. As a point, the words are extraordinary and compelling. That's a high standard. And it suggests that, individual determinations, because what is extraordinary and compelling in one case may not be extraordinary and compelling in another case with different individual characteristics.
Well, Your Honor, 2 points to that. First, it is not a case-by-case analysis, and that is what the policy statement says. And other courts have found, United States versus Hickson found that it specifically qualifies. In the Western District of Virginia and Soles, they found it was a per se qualification. The government conceded in both Soles and Mumford about this per se qualification. And to the second point there, even looking at the specific characteristics here of Mr. Hawley, it is still an abuse of discretion. Mr. Hawley is on a downward spiral, and the record supports this. When Mr. Hawley was sentenced...
But it seemed like to me there was evidence that some of that was his own making, right? He was failing to comply. And one of the challenges with this per se rule, right, is if you say that, as long as you get this disease, you encourage people to not comply with the medications and procedures that would keep them well in order to qualify for this relief. And maybe that's like fanciful, but it seems odd that your suggestion is that a district court can't consider these failures to comply with the medical process as determining whether this is like an extraordinary and compelling circumstance.
Judge Richardson, so what the district court did here shows the need to our second point of the expert nephrologist, because it misunderstands what compliance here means. When you look at the record from our count, there were 161 instances of treatment. And they started at 4 hours per session, 139 of those. 39 he ended early for only 20 minutes due to cramping, extreme pain, worry that a kidney cyst might actually burst. That's on JA 466 because of the pain. And then when they ramped it up to 5 hours.
Okay, so I understand the second argument you're making, and we could shift to that one, but that just ducks the question, which is like, if you had every expert in the world, your theory is it doesn't matter, right? Your theory is it doesn't matter if he literally ignores everything and did nothing and instead drank poison every day, that none of that would matter because, if he's got a doctor that says end-stage renal failure, he passes the hurdle.
Well, Your Honor, we're not arguing that that could never be considered. And the cases that the government cites are more similar to what you stated about United States versus June. That was a complete.
But if you have a per se rule, how could you consider it? I mean, your theory is that it's a per se rule.
Well, it would be
You ought to stick with that. I mean, it might be a good argument, but you can't have a per se rule that takes into account other stuff, because then it's like sort of definitionally not a per se rule.
Yes, Your Honor, and it could be considered holistically as compassionate release is. But the point here that he was complying, he was having up to, on JA 1013, up to 6,200 milliliters of fluid taken off at a time. That's 13.7 pounds. This is why he was ending treatment early. And to the second point here is that another reason he wasn't able to comply and he was gaining so much fluid was because of the inadequate diet he was receiving in the BOP. JA 103, he sends a letter to Dr. Dixon, his nephrologist, where he states that they're supposed to have kidney-friendly, renal-friendly diet options. That day it should have been either chicken or eggs, and the only option was pizza. There's another letter, JA 104 to 106, from a fellow inmate that states he tried to help Mr. Hawley with his diet, but the only way to get an adequate diet was through the commissary. And everything on the commissary is also not renal-friendly. So he's actually, the problem is getting worse, and he is on this downward spiral. He entered prison not on dialysis. He was at 15%, JA 134. Now he is JA 737, he's at 4% kidney function. Mr. Hawley is in a severe downward spiral due to the...
You're giving your view of it, but you're not quoting to me from district court findings.
Your Honor,
It's almost like, listening to your argument, the district court didn't really exist. I mean, isn't there something that you could quote to me from a district court finding that would support the point?
Your Honor, we wish we could quote something from the district court's opinion about his need for a kidney, but the district court made no mention of his need for the kidney. So that's under a subsection C argument of whether he needed specialized care that he was not receiving. And here that is a kidney transplant. The only standard of care for a person with end-stage renal failure is a kidney transplant.
Well, all right, if you're on the outside, if you're released from incarceration, kidney transplants are very hard to get. Anytime you're talking about an organ transplant, being a heart transplant or being a kidney transplant, there are often a significant shortage of organs out there.
Your Honor.
And whether you're incarcerated or whether you're not incarcerated, there's a long line. And it's not clear to me that somebody is going to get a kidney transplant if they're on the outside and is not going to get a transplant if they're on the inside.
Your Honor, Mr. Hawley has identified 3 people willing to donate him a kidney. That's JA 57. And he has stated that because he's in prison, they're not even able to be evaluated for his kidney transplant. Mr. Hawley is only asking this court to reduce his sentence very modestly, 7.5 months. The BOP indicator has him being released December 21st of this year. And for these reasons, we ask this court to reverse the district court's decision. Thank you.
Judge Richardson, Judge Burns.
May it please the court, my name is Gabriel Price on behalf of the United States, and we're here asking that you affirm the district court's denial of compassionate release in this case. The district court did exactly what we expect district courts to do. It reviewed the records and it utilized its discretion in determining that there was no end-of-life trajectory presented in those records. Nothing in the records indicate that there's any kind of eminence or path towards death.
Do you agree that end-stage renal disease is end-stage organ disease? I mean, kidneys are an organ.
I agree that it can be. I agree. The government's position is that when looking at those, and I cite to the Alexander case in my brief, that court did a good job of describing how to view end-stage organ disease in the context of terminal illness and looking specifically at, that's a general term for end-stage heart disease, end-stage liver. There's a lot of different conditions that could potentially impact there, and not all will be terminal. And in this case, the definition for terminal illness is a serious and advanced illness with an end-of-life trajectory. And the district court in this case
Although
found.
the end-of-life trajectory doesn't need to be within a specific time period, and people do die of renal failure when they have it, stage 5.
They do at some point, but again, what was before the district court and the research, it can be 5 to 10 years, it can be 20 years, it can be 30 years. There is nothing specific in this case as to Mr. Hawley as to how his end-stage renal disease was progressing. There's no letter from his nephrologist.
So you
within the
are
person.
then contesting the supposition that end-stage renal disease is end-stage organ disease? You're saying it's not necessarily the case?
I am resisting the proposition that it per se qualifies as a terminal illness, yes. I think for a terminal illness, you have to show both of those. And I think end-stage renal disease can be a terminal illness if, after looking at all the records, that is supported. And that's what the district court did here.
Then can you address this question that we were talking about with your friend regarding the policy statement and whether or not it's binding on district courts? I mean, I think that question was resolved in our Crawley opinion from last summer.
And Your Honor, I'm not familiar with Crawley specifically. I do know, in talking about the Booker decision, where the guidelines are no longer binding on the courts, the courts are given a lot of discretion. Now, I believe district court has an obligation to consult the guidelines, to review them, and to analyze the case under those. But again, I think the district court should be given latitude and discretion, especially in something like releasing compassionate release motions, where that really is the height of where a district court should have their discretion. They're in the best position to look at the entire case. Now, many times the same district judge that presided over the case will be presiding over the subsequent motion as well. And in this case, you have the medical records provided show that the type of dialysis that this appellant was receiving, the LLE Waveland Q was working well. That's at JA 297. The most recent notes from the nephrologist, there was nothing in there indicating any kind of decline. There were, and that's JA 910 and JA 943 that was May 4th, 2024 notes, shortly before this motion was filed. They indicated there's no complications with dialysis. The records that the district court had before and was reviewing, there's nothing in there that shows this decline. There was a fall that occurred roughly a month and a half prior to, I believe, the motion being filed. There's some sleep apnea, but nothing in regards to the end-stage renal disease. The defendant's burden here, or the appellant's burden here, was to provide that to the district court. It didn't do that, and it just simply is not there. The district court's discretion on that should be affirmed. Additionally, in looking at the specialized care with the transplant, there's nothing in the record that indicates a transplant that this specific appellant is appropriate for a transplant. He never requested a transplant. In the letter that he sent.
You say he never requested a transplant?
There's nothing in the record that he requested a transplant through the Bureau of Prisons.
Was he ever denied one then?
No, because he never requested one. When he sent his initial request to the warden sent back a response denying it, but telling him he could raise that with his nephrologist. He sent.
So one question I have here is that this is obviously a serious situation. It's true, as you say, that the outcomes on dialysis are significantly different, and that the individual's situations are significantly, the individual circumstances vary considerably. And maybe this is best asked to your opponent here, but I'm not sure why don't these cases of this sort go to an inadequate care within the facility as opposed to a motion for release. That's one thing, because you have to have some sympathy for the individual in this situation. It's not, dialysis has tremendous advantages, and gosh knows what people would do without it. But on the other hand, I have to believe that some prison facilities administer dialysis in a very effective way, and other prison facilities probably less so. And as I say, maybe this question is best directed to your opponent, but I'm wondering whether the same results or the same aims couldn't be met with an Eighth Amendment claim of inadequate care within the facility, rather than a question of release where the standard of extraordinary and compelling is very high.
And I'm going to agree with you, Your Honor, about there is sympathy for a person in this scenario. However, the record in this case doesn't show inadequate treatment. The record in this case actually shows adequate treatment. He's getting the dialysis he needs to survive.
Okay,
He's
but
responding well to it.
But I suppose that would say something if we're talking about any condition and the treatment that afforded the condition would not support an Eighth Amendment claim or a claim of inadequate care, that would seem to diminish somewhat the case for an early release.
Yes, Your Honor, I would agree with that. If he's being provided with adequate care and he's responding to that adequate care, I think that diminishes both an Eighth Amendment
But
and
I'm
a
wondering why the
compassionate
first
release.
resort in these cases should not be a claim of inadequate care. And if that's not going to go forward, it seems to me to diminish somewhat the extraordinary and compelling reasons for compassionate release, because Congress has used some adjectives which suggest a very high bar, extraordinary and compelling.
Yes, Your Honor, I agree with that, and I think that there are different ways to approach this. The appellant in this case chose to approach it through a motion for compassionate release. I feel in reviewing the cases for here, that is quite common in the prison setting. There's a lot of motions for compassionate release. I can't really speak to the Eighth Amendment claim. I think that would be something that the individual appellant would have to look at. But again, I agree. I think it comes down to that discretionary decision and that extremely high bar in reducing a sentence. District courts are given a limited authority to reduce sentences, and within that limited authority, they are provided that discretion. And in this case, I also want to point out, although the appellant did state in his motion that he had 3 individuals that were willing to provide a kidney for a transplant.
He says that the care was inadequate because it caused him a lot of pain. What is your response to that?
I didn't take his argument specifically as it's inadequate because of the pain. I believe the argument is that he's saying the dialysis is causing pain, so that's why he's ending it early. And he wants to pursue a kidney transplant and says a sister and 2 friends without naming them or providing any evidence.
With the dialysis, if the problem is that the dialysis is causing pain, do we know if the dialysis was performed outside of the institution? Would that cause less pain, or is it?
I don't, that would not be in the record before the district court. I do know that in this case, the medical records provided do state that dialysis was working well for the appellant.
So the medical records say that the dialysis was working well?
Yes, Your Honor. It says there are no complications with dialysis. It says the LLE Waveland Q, which I believe is
So
the
is there a
specific
reason to
machine.
believe that if they were released, that the dialysis would be working less well?
I think the reasonable interpretation of that would be it would be working the same. I don't think it would be any different. I think dialysis within the prison setting or outside the prison setting, 3 days
I
a
just got a
week.
lot of questions that I'm just, it's easy to say, well, you're hard-hearted, you know, you've got a person with something that we would all extend our sympathies to. It's a sad situation. All of this is a very sad situation, but, you know, it's not being hard-hearted. It's a question to try to find the answers to how we square what's happening here with what Congress, the language that Congress used, and the facts that the district court found. And at any rate,
And I agree, it's a very tough decision, and that's why the district court has that discretion yet again, and why the burden is ultimately placed on
yeah, I
the
mean, one of
moment.
the questions you have is, that, given the condition, and it's a serious one, is release the answer?
And I would say, if you're looking at it from an equitable standpoint of what compassionate release is supposed to be, you know, to get treatment outside, better treatment outside, there's nothing indicating that he would get better treatment outside. There's nothing indicating he would actually get a transplant. It's a very difficult
Well, that's
process.
the question I have is the condition is a sad one, but is release the answer?
And
I don't know.
I think the district court answered that with its order denying release, and specifically, when looking at the non-compliance issues, I think the district court considered those. In looking at the list of what he's specifically purchasing from the commissary, chips, cookies, things that are not good, they're phosphate-added foods. Additionally, he stated that.
No, I'm not prepared to be hard-hearted on this kind of thing, but if I'm just given some reasons that in the findings of the district court that release would be the answer to what we all think is a serious problem, then it becomes a different case for me, because you could say, yes, compassionate release is called for because this is going to be substantially better, but that point has not been developed.
That's correct, Your Honor. The district court down below specifically was focusing on the first step of extraordinary and compelling circumstances. It explicitly declined to address the administrative remedies point raised by the United States, and it did not address the 3553A factors. If my friends on the other side ask this court now to remand with instructions to grant compassionate release, that would not be appropriate. If this court did remand, it should be to consider the case, the 3553A factors and the administrative remedies question for the first time, as it has not considered that prior.
Well, let me ask you this, would you, but in order to remand, we would have to decide that this was, that the district court had erred in finding no extraordinary and compelling reason.
That's correct, and that's why today we're asking that you affirm on that ground, because the district court did not abuse its discretion in that finding. However, the, I guess, fallback position of the United States is that if this court disagrees and finds that the district court did abuse its discretion on that first question of extraordinary and compelling circumstances, then the proper remedy would be a remand for consideration of the 3553A
Well, I suppose that an
factors.
extraordinary and compelling reason is open to the district court discretion in the same way that the consideration of the individual factors were.
Yes, I believe that is true. The questions around compassionate release should always be in the discretion of the district court, and that's why we're asking to affirm on that discretion. The case cited by appellant, the Malone case, that did remand with instructions to grant, was a very exceptional case where he'd already actually been released to home confinement. So he was no longer in the prison setting, They already found the.
Can I back up to the question that I bothered your colleague on the other side with? And you can just say you don't have a view on this, because I'm not trying to pin you down, but it strikes me as odd that we care so much about what the sentencing guideline says here. It seems like, the Supreme Court has this compassionate release case before it now called Fernandez, and they debate about what falls within extraordinary and compelling circumstance. And nobody in that case, the court nor the parties, thought that the guidelines were controlling or binding in some way. They're trying to look at what the statute says and what it means. And I guess I can't tell whether that's just like a post-Loper Bright, that, we have a statute and so we should look to the statute rather than, the Sentencing Commission's, riff on what extraordinary and compelling circumstances mean. Do you have any insight to share with me? There seems to be this premise in the briefing, but also in some other cases like Crawley, that get to the question of whether this guideline is in any sense binding on the district court. And it seems ambiguous to me at best. And it seems a little inconsistent with Fernandez that there's all this argument and nobody's like, oh, we should be looking at the guidelines. I mean, I think they cite them in the brief somewhere, but the argument is not about what the Sentencing Commission said. It's about what does the darn statute mean. Well, you've presented this case as a question about the sentencing guidelines. I acknowledge that. But why is it not really a question about what the statute says? And we can give Skidmore deference all we want to the Sentencing Commission, but nothing more?
Yeah, I would say, I don't think that's really been delved into in the briefing in this case.
Yeah, that's obvious. Yep.
But I would say that when looking at what Congress intended, you always start with the text of the statute. I think the sentencing guidelines are a good tool for the district court to use, and I think that's the way that the district court should view them. When looking at.
But if it's just a tool, like the failure to follow them to the letter, it doesn't seem like an abuse of discretion, right? If instead it's a binding, mandate on the district court, which is sort of how it was been presented here, then the failure to follow them to the letter is a real problem, right? So it sort of matters what we think this is. You just said it's a tool. That seems fine to me, but I don't know where I get that from, other than the sort of notion that we really are bound by the statute and not the Sentencing Commission's, riff on what they think is a extraordinary and compelling circumstance.
Yes, and I would go back to kind of the Booker formulation with the sentencing guidelines there as well, and how that's taken in. I think in this case, though, such as other cases where we talk about substantial reasonableness of sentences, there's always, a district court may always abuse its discretion in certain ways. If it wholly disregards everything and doesn't consider things and just kind of doesn't follow any kind of standards, I think that would be an abuse of discretion. That's not what we have in this case. In this case, I think the question you're asking isn't necessarily dispositive of anything. A per se rule would not be an appropriate rule. I think appellate courts are typically not in favor of creating these per se rules, and that's
It just would be odd to create a per se rule in a non-binding policy guideline, right? That's sort of like oxymoronic, right? Like,
Yes.
to have a per se rule that's not binding on anybody doesn't seem to make sense. But if it is binding, then maybe a per se rule makes sense. Anyway, y'all haven't argued all this. I'll let you go with that.
I see I'm about out of time, so I would just ask this court to affirm the district court's denial of compassionate relief in this case. Thank you.
All right. Counsel, you have some time for rebuttal.
Your Honors, 3 points on rebuttal. First, to address Judge Richardson's question about the policy statement again, Congress directly delegated this to the Sentencing Commission under 28 U.S.C. Section 994T. And the error of law that this court reviews de novo under its United States versus Mitchell question of the interpretation of the guidelines, the district court didn't engage with it at all. It listed a specific example in the policy statement for end-stage organizes. It never mentions that at all. And to Judge Berner's earlier question to my colleague, there's no reason why Mr. Hawley's did not qualify here. And to have something on, there would have had to been something in the opinion to say why his is different than the specific example Congress asked the commission to provide. And to the United States versus Alexander case that the government cites, that specifically was a stage 4 end-stage renal. It was not end-stage renal failure. So this idea that it's an individualized assessment because of United States versus Alexander is wrong. That court specifically said if it was.
District courts all over the country splitting on this, and wouldn't that suggest that the question of extraordinary and compelling is not to be answered categorically, but would reward individual inquiry?
No, Your Honor. In fact, the courts really aren't splitting on this issue. There's a few outliers before the policy statement became binding under Amendment 814 where they went the other way, but the overwhelming majority are finding end-stage renal failure. As the Western District of New York recognized, United States versus Davis, district courts have regularly found end-stage renal failure to qualify under the guidelines.
So you're saying that the extraordinary and compelling is purely a question of law and that the other is a question of fact?
Yes, Your Honor. The 3553A questions are a question of fact, but this is a question of law.
And you don't disagree that the two issues that your colleague on the other side said would need to be addressed in the first instance by the district court, if we were to agree with you, that it would be most appropriate for us to remand to the district court to address those issues in the first instance?
No, Your Honor, this court should address it as it did in United States versus Malone because of this extraordinary situation where Mr. Hawley is in dire need of a kidney transplant. He has been on dialysis for over 5 years. The average life expectancy on dialysis is 5 to 10 years, and only 35% of dialysis patients make it to year 5. Mr. Hawley needs this now, and because of the urgency, we asked this court to find it because the 3553A factors weigh heavily in Mr. Hawley's favor. He's asking for a modest reduction by this court, and he is not a violent criminal. He has shown no violent pattern in prison, and he has shown that he is being rehabilitated. He has completed many different courses, JA-71, and has been a model prisoner while in.
Why in the world would we just ignore this and short circuit the district court and say, well, we're going to make findings of fact up here?
Well, Your Honor, because of the urgency and because Mr. Hawley needs this transplant, that is why we're asking for this extraordinary remedy. We recognize this.
Did he ask for the transplant?
Yes, Your Honor. On the record,
your opposing counsel said he never asked for it.
JA-85, he stated to the warden, I want to get a kidney. That was his whole reason for this. He has stated he has people willing to donate. He's wanting to get the kidney. That's the point here, because a kidney functions 24/7. And to the government's point that he has not shown any deterioration on dialysis is wrong. He went in with 15% kidney function, JA-134, and is now at 4% kidney function, JA-737. And the idea that dialysis is working well is also wrong. He's having cramping. He's had to stop. He has dialysis-induced nausea, lethargy.
Is release the answer to this?
Yes, Your Honor, it is, because that allows him to get on the kidney transplant process and to get this chance at life again. His mother died from this same disease. It's a genetic disease, polycystic kidney disease, which is on the record at 94 and 134. His mother died of this. He has had 5 heart attacks. He has heart disease, chronic lung disease. This is all JA-85 and 134. And every day he's on dialysis. He gets dialysis 3 times a week for 5 hours a time. That means the other 153 hours of the week, his body is filling with fluids, with toxins that he cannot expel through urination, and is causing extra pressure on his heart, on his lungs, and everything else.
That would be the effect of dialysis outside of the incarceration, would it not?
Well, Your Honor, yes, but it allows him to start the kidney transplant process, which he is not able to do in prison. And for all of these reasons, to prevent Mr. Hawley's sentence from being...
Why didn't you bring an Eighth Amendment claim of inadequate treatment or inadequate care?
Your Honor, I see how my time's expired. May I answer your question and briefly conclude? Sure. Well, Your Honor, this goes to kind of our second issue of the failure to appoint counsel. Mr. Hawley is a man that's on dialysis that realizes that he, JA-101, that he has such post-dialysis exhaustion, he misses scheduled medicine distributions because he's asleep and he's so tired. And to have him bring all of these claims pro se, without counsel, a man that is so tired and when he's not hooked up to a dialysis machine that is dying, that we would bring that claim if he had been appointed counsel, but he was not. And for these reasons, to prevent Mr. Hawley's sentence from becoming a death sentence, we ask that this court reverse the district court and remand with instructions to grant compassionate release to Mr. Hawley to give him a chance at life. Thank you.
Thank you. We will adjourn court and come down and greet counsel.
This honorable court stands adjourned until this afternoon. God save